Someone make it make sense.
Probably a couple.
Hello, we're back for more Party Squirrels of the World. Yeah. I'm such a weirdo. Such a weirdo. But you know what? It's all good. We love weird people here. We love all the squirrels. So here we go. What we have going on here at the beginning, there's audio, but no cameras yet. So we're getting ready for the freeze. This is the hearing just from today, guys, right? After the whole fallout from last time. Remember, Judge Bev got off the bench. She was all mad. She was shaking. She ended it early. She didn't let the defense respond. It was a whole big thing. It was like, what the fuck? You know, just in case anyone didn't see it, right? You know, there were all these allegations made by the Commonwealth, specifically King Brennan, and mostly pertaining to the ARCCA dudes, and like potentially they were paid. And she ended the whole thing after having like a hissy fit and like didn't let the defense respond. So today we are back for the defense, for their response and the rest. Heather's back. We missed you last time, Heather, on the last one. Quiz is celebrating for the 22 seconds. Excellent. We were talking about you, Heather. Welcome back, P. Fox, as well. Put her in the corner. There we go. There's the only fan. Excellent. You're just Bev.
All right, please.
That's good.
You are unmuted.
22117, the Commonwealth versus Karen Reed. Can I have counsel identify themselves starting with the Commonwealth?
Good morning, Your Honor. Laura McLaughlin for the Commonwealth.
Good morning, Ms. McLaughlin.
I'm Lyle for the Commonwealth.
Good morning, Mr. Lally.
Good morning, Your Honor. Hank Brennan for the Commonwealth.
Good
Why
morning,
is
Mr.
he even
Brennan.
there? Sorry, why?
Good morning,
Oh.
Mr. Jackson.
Why the fuck is Lolly even there? He does literally nothing.
Your Honor, Elizabeth Little, also on behalf of Ms. Reed.
Good morning, Ms. Little.
Good morning, Your Honor. Robert Alessi on behalf of Ms. Reed.
Mr. Alessi.
Good morning, Your Honor. David Inetti for Karen Reed.
Good morning, Mr. Inetti. Good morning, Ms. Reed. All right. So last week, upon hearing of a previously undisclosed relationship, perhaps, between defense counsel and the ARCCA witnesses.
Here we go.
I took a recess here. I
Okay.
was suspended. I had heard about email communication, detailed communication, memorializing a conversation regarding an engagement letter and a promise of retainer on March 20th and 22nd of last year, roughly 2 months before the ARCCA witnesses testified. There is another email that was 2 days before the trial and after the voir dire, 2 days before the trial with a list of cases. The Sunday before.
Remember, we pointed that out. That's an important distinction, right? Because the rules, the questions that were asked were about their communication, or at least that we were able to hear on the record. We went back and looked. The questions that were asked about when did they communicate and what and that was before voir dire. And then after the voir dire is when they had some communications, but it wasn't clear to us because we don't have access to the written order. But verbally, you know, it wasn't discussed that don't talk until testimony, right? So that was one of the things. And of course, there were also things that were undated as per Hank Brennan. Like, for example, the fee thing.
Witness testified. There's a proposed script of questions and answers and suggestions. And after the trial, there is an invoice or a bill, not just for reimbursement of travel and expenses, but for trial prep. Clearly, the ARCCA witnesses were expecting to get paid.
Now, I will be interested to hear more about that. Let me listen again. Yikes.
File, there is an invoice or a bill, not just for reimbursement of travel and expenses, but for trial prep.
Okay, wait, hold on. Did she say, because the bill was undated, do we not have the date yet? It could be for this upcoming trial, right? Hold on. Let's just see if she gives a date.
Questions and answers and suggestions. And after the trial, there is an invoice or a bill.
When after the trial?
Not just for reimbursement of travel and expenses, but for trial prep. Clearly, the ARCCA witnesses were expecting to get paid. So
We'll see.
the
We'll
Commonwealth,
find out.
so I suspended for 3 reasons. The Commonwealth raised questions of candor with counsel in the court regarding the Rule 14 obligations. And frankly, I didn't think it was fair to have defense counsel stand up and have to answer to that
Yeah, but they
without the
represented they weren't
opportunity
getting paid.
to reflect, to talk to each
It's a
other.
big problem. If in fact they were paid for that first trial, that's a problem. Big problem. Because that was the whole thing, right? They were not getting paid. And we were all thinking they were being paid by the government, you know, the federal government or whatever. But we'll learn more. We'll see what happens.
To look at transcripts, to consult with people, and that it made sense to give you some time to do all of that, because what the Commonwealth raised does raise serious issues, not just the rights of counsel, but Ms. Reed's right to a fair trial and all that that entails. So it made sense to me to suspend first and foremost for that reason, so counsel can be prepared to make any comments if you choose to. Second reason is what the Commonwealth told us is inconsistent with my memory. So I wanted to make sure that my memory was right. So in a way to do that, I went back and reviewed the transcripts again. I started with the June 10th transcript of the discussion with Mr. Yannetti, where I raised my skepticism about defense counsel in a murder case calling not one, but potentially 3 witnesses that you never talked to. I looked back at the June 18th voir dire hearing, the June 24th trial testimony of the ARCCA witnesses, and the June 25th closing arguments of counsel. So after reviewing that, and my memory was pretty good about that, but what concerned me most is the memory that I had of a discussion here at Sidebar on February 6th, so 3 weeks ago, not last June, outside the hearing of everybody in this courtroom. And at the time, I was operating under the assumption that counsel was unable to provide the Rule 14 discovery because of a federal protective order. And the discussion at Sidebar clearly revealed that, and counsel did nothing to disabuse me of that. So I asked the trial court to expedite a hearing, a transcript of that hearing. Mr. McDermott's going to mark it as evidence. And at that point, Mr. Jackson, when you didn't answer me at first, but when you did, you said, I can tell you this. The Commonwealth is saying, pursuant to Rule 14, and you know, exclusion and preclusion of a witness is a punitive sanction for Rule 14 violations. Ms. Reed has not violated anything. Why should she be penalized when the Commonwealth has the exact same batch of information that we have about these witnesses? So I don't have any more information. I don't have any additional discovery. I didn't hire them. I didn't ask them to engage in additional protocols. So I've got nothing else to give Mr. Brennan. He's got the same information I got, and he got it at the same time.
Now, I want to reiterate another thing. The only communications that we've known that we have been brought up have been between Alan Jackson and Dr. Wolfe. We've not heard anything from Alan Jackson to Dr. Rentschler. We've not heard anything about Mr. Yannetti to either of them. It looks like it was just between Alan Jackson and Dr. Wolfe. So I just wanted to reiterate that.
So that was concerning to me. Jim, do you have a copy of that there that you can? And I made sure, so the transcript is of the entire hearing because I don't want anyone to think anything's out of context. So we will mark that as an exhibit.
Thanks, Jen.
And the third reason I paused is because, frankly, I needed time to reflect. I don't know what may flow from this. Obviously, I have to make findings, whatever they may be. But I wanted to explain why we recessed. I sent that one-page notification out last week about what we would be discussing. So I will hear from defense counsel.
Okay, here
if
we
you want
go.
me to hear from you. If you don't want to say anything, That's fine too. But if you want to be heard,
Fuck you, Bev. I'm sorry. What? Are you pulling a Hitler like you've already made up your goddamn mind? Is that what that is? Like, it doesn't matter what you say. Please, for the love of God. If you don't want to be heard, that's fine. Why would they not want to be heard? What is wrong with you? Literally. It was bad enough that you ended it early and didn't let them be heard last time.
I will hear from defense counsel.
Your Honor, thank you for the opportunity to be heard. I am
Okay.
going to be responding on behalf of defense counsel.
Okay.
Very smart move.
All of your concerns. I have a notebook that I've given, albeit just now, to Mr. Brennan. It's got exhibits, but it's everything that everybody's already had. It's similar to what you're doing, transcripts, documents, probative issues. And if, with Your Honor's permission, I'd like to provide you with the notebook so that you can follow.
That'd be great.
And should I hand it to someone here to have it handed to you or bring it
A
up?
court officer will take it for you.
Incredible. Look at this is, dude, you gotta love it. He's not even gonna, he's like, how would you like me to get this binder to you? Should we pass it? Because he knows you have to ask for permission to do everything. But this binder, dude, is magnificent. The way he has it tabbed out, so impressive. This is beautiful. This is just like, makes me so happy. The way that he has it tabbed out, this dude is like so fucking organized.
Yeah.
It's crazy.
I appreciate that,
He
Mr.
did
Alessi.
this
You're
so
welcome.
quickly. These copies for everybody. Look at him, so prepared. Incredible,
There's another notebook.
incredible. This is so impressive.
And with that, Your Honor, I'm going to go to the podium and make my presentation.
Okay. You know what? Actually, I'm going to take 5 minutes to just quickly go through this.
That would be
That's
excellent. Thank
crazy.
you, Your Honor.
You're gonna take a break. So 7 gigabyte. That's interesting. How long is it, Heather? That video that you're talking about there.
I know. Okay. Okay. Sorry.
They're right up there. They're right up there.
You are unmuted.
No, yeah.
All right. So I apologize if that wasn't quite 5 minutes. I just wanted to see what it was that you had there.
Are you comfortable with seeing the notebook?
Yes, if I haven't read everything, but I know what each of them are.
Oh my God,
Yes.
what? I have the wrong banner up. Sorry, guys. Where did it? Oh, weird. It got moved. There it is. Weird. Okay. Interesting. I had the Casey Anthony banner up somehow. Okay, there we go. All right, time for the defense argument. Oh my God.
May I proceed, Your Honor?
Sure.
Thank you. May it please the court. I understand the moment. The moment has categories and components. And in my presentation today, Your Honor, I am going to go through those categories in this order. I am going to start with the notebook that I handed to Your Honor and to Mr. Brennan this morning. The notebook is purposefully in chronological order. The notebook is in chronological order because I believe the best explication of the facts and what those facts mean come from a proper chronological presentation of the facts. I also believe that the chronology is going to address many, if not all of the concerns as I understand from Your Honor. Your Honor, of course, will be the ultimate arbiter if they successfully address those concerns. But my intention,
Interesting.
Your Honor, is not to obfuscate, not to conflate issues. To the contrary, my intention is going to be to elucidate and to illuminate so that Your Honor can make the proper
He's so funny.
determination. That is my genuine goal for my presentation. As I go through, and I know I don't have to say this to Your Honor, you can feel free to interrupt, pressure test me on anything I'm going to say. I would welcome it, but I believe if I can get through the chronology, my hope is that the facts will speak for themselves. But that brings me to my second component of understanding the moment, which is going to be to also add to the fact is what happened at the last hearing, on February 18th. And I have the transcript for that, and I have that in the notebook, because I believe that is also critical to the proper elucidation of the facts.
So that's the only thing I have not previously seen.
The February 18th transcript. There are 9 pages that I'm going to go through, Your Honor. And because of the stakes here, I am going to go through it hopefully efficaciously and efficiently, but it's going to have to be methodically.
All right. So are you're addressing this in chronological order as well, right? So if you can tell me those pages now, I'll likely recess because I do want to see them before you talk about them, but I'll hear you going up to that point. So what pages are those?
And you're referring, Your Honor, to the February 18th transcript?
Yes,
Yes, I
your
will
number.
tell you exact
8.
pages that I'm going to refer to. And Your Honor, get to this is tab 8,
Right.
the notebook.
Mhm.
And specific pages that I'm going to reference
Tabs
start on
is the brilliant system. Why doesn't everybody do that?
page 53.
Okay.
And those are 9 pages that proceed all the way to, really, the substance ends on page 62.
Okay.
And I appreciate that Your Honor wants to take a look at them because I think it's incredibly important for putting in context what happened at that last hearing. And I think it helps also do a compare and contrast to what the actual facts are and to what the statements were that were made on the 18th. So if I understand, Your Honor, that you would like me to
You
suspend my
can,
brief or keep
no,
going?
no, you can keep
Okay.
going and we'll stop so I can read whatever I think I need to read
Sure.
at certain points, but we should be good to at least start.
Thank you.
And can I just ask, when was this put together?
Started about a day and a half ago and was completed this morning.
All right. Go right ahead, Mr. Alessi.
Thank you, Your Honor. So I start with tab 1, which is the March 22nd, excuse me, go to the bottom, please, the March 20, 2024 email. And this is an email between Mr. Jackson and Mr. Wolfe. It was sent from Mr. Jackson to Mr. Wolfe. It was entitled Engagement. And so what I'm going to do is, that's where the notebook starts, but I want to go backwards to start in terms of something that is well known. And that is the federal investigation and the products of that federal investigation produced the ARCCA report. And that was in February of 2024. So what preceded this communication was a production of materials from the federal government, about 3,000 pages. Contained in that 3,000 pages was the ARCCA report of February of 2024. There was no index of the 3,000 pages, and the defense came upon that report. They got to reviewing the documents in March of 2024. And as Your Honor will recall, the trial 1 started in April of 2024. So it was pretty close to when that trial started. And
I
know
will
Your
reiterate too. Remember, we saw that bill, right? Thing I brought up last time, that we don't know who the bill is from or to, or if it was ever paid. And just from the way that Judge Bev read it, same is true, right? It could be that it was, we just don't know. I just wanted to reiterate that we don't know the circumstances yet of that bill.
Your Honor knows from both your judicial experience and other experience that when you're entering into a trial of this significance, there's a lot going on. And so what happens is that report's produced in amongst 3,000 pages, it is located, it is read, the significance of it is immediately discerned. The report, basically the findings of the report, that the vehicle, and the substance is important, Your Honor, because it really informs a lot of the emails. The substance of the report speaks to the issue of whether or not the motor vehicle of Ms. Reed made contact at all with the decedent, and whether the decedent's injuries at all reflect a contact with that report. Those findings in that report was set in cement in February of 2024. What do I mean set in cement? It means they were never changed, nor could they be changed. So that report was provided to the Commonwealth and to the defense. Next step, important also. Any party, the Commonwealth or defense, had access to ARCCA. They had the opportunity to contact ARCCA. There were restrictions that I'm going to get to on that contact, but either party had the opportunity to contact them. Now, only the Commonwealth knows why they didn't take that opportunity. It may be because of the findings. It may be for other reasons. I don't know, but I understand the
we all
facts
know why.
that the Commonwealth didn't make contact with the ARCCA experts. The defense surely did. So that is the background. That is the information that we have. And so what happens? The defense sees the report, sees that the information in it is completely exculpatory to Ms. Reed. Of course, any attorney, lest they want to risk malpractice, is going to make a communication with that expert, which was perfectly legal and perfectly contemplated by the rules of the road, if you will. Now, as Your Honor also knows, the rules of the road with regard to the ARCCA expert were not set by this court. They were set by the U.S. Attorney's Office. And I'm importantly going to articulate with objective evidence what those rules of the road were. But the one key point is those rules were not set by this court. So the contact was made. This is one of the most unusual situations I've ever seen in my practice of law, meaning you have these experts,
Right.
you have great exculpatory information, but there are significant constraints on how it is you can interact and utilize those experts in a complete unorthodox situation. Why do I emphasize that? I emphasize that because lawyers in trial practice are used to doing things a certain way.
It looks
And when
27.
there are certain constraints that are imposed upon them, it becomes more sui generis, more ad hoc. And then there has to be sort of new ways of addressing the situation. That now brings me with that important background to tab 1. And to
Tab one.
repeat, the communications start with a report from the ARCCA experts and their findings and their conclusions that never changed. They never changed from the report they generated until the first
I have no
communication in
idea.
tab 1. It may seem self-evident,
Oh, you're
but
talking
given
about this-
the moment, I'm not going to take anything as self-evident.
What?
The defense had zero input into the report and therefore
I
had
don't-
zero input into the findings. And in fairness to the
I don't think he's
Commonwealth, nor
67.
did the Commonwealth. So
I don't think he's 67.
with that, we
I
come
will
to
say, I don't think he
the,
looks 27. I mean, you can see he's losing some hair there in the back. No offense to him, but I don't think he's 67. I'll see if I can find out though.
emails on tab 1. March 20th, Mr. Jackson to Mr. Wolfe. Please note that there is no CC to Mr. Yannetti. Why is that important? When we get to Massachusetts Professional Rule of Conduct 3.3A1, that fact is going to become extraordinarily important. So we have a communication, and it needs to be read in its entirety. Fortunately, it's short. Dear Dr. Wolfe, thank you so much for taking the time to get on the phone with me this morning. Pursuant to our conversation, please feel free to forward an engagement letter to this email address. I will get that countersigned and returned to you forthwith, along with your retainer, as required. I have the good fortune of dealing with experts probably every week. And this is classic foreign parlance. If it's going to be required, you always hope for your client that they're not going to require a retainer. But the language is as required, as. Also, if you could attach a copy of your Dr. Rentschler's and Mr. Klein's CV, I would appreciate it. I look forward to speaking to you and your team soon as we iron out the logistics for your participation in the trial. At that particular point in time, there was no conclusion, no agreement, no knowledge that these
What kind
folks
is
would
age?
actually be testifying. There was certainly the hope, there was certainly the desire,
That's
but
true.
there was no agreement that they were going to be testifying. That was the
Was the federal protective order that was referenced by Mr. Yannetti that said it was, and it was specifically outlined in rule that they could not prep with us for trial. Was that in effect at the time these emails were sent?
The answer is, Your Honor, and I'm going to get to it, but I want to answer your question.
I'd like you to answer my question.
Yeah, I wanted to say it. I'm going to answer it directly. What Mr. Yannetti articulated as the rule of the road, not prep, was not a rule of the road. That wasn't the rule of the road, and I have objective proof of that. The rule of the road was there would be no substantive conversations with the ARCCA experts. Okay, that was it. But the answer to your question is I do not know whether the ground rules were in effect, but I can get you that answer, and I will get you that answer hopefully in moments during my presentation. But I do not know the answer.
All right, go ahead.
And it's an important question, and it's an important answer, I understand. But I'm going to give you information that's going to indirectly answer that question, but I'm going to get you a direct answer as well. So you see that there's an attempt to iron out the logistics for your preparation in the trial. Then we get to the email up above, and that is merely 2 days later. Again, Mr. Yannetti is not copied on the email, and my understanding is Mr. Yannetti is not knowledgeable about these communications. So in the email reads, "Hi, Alan, subsequent to our conversation on Wednesday, the U.S. District Attorney's Office has asked that we pause on any further conversation until we receive additional information from their office regarding our involvement moving forward. I will provide you an update when we have it." Your Honor, this is not a direct answer to your question, but this is, to me, going to corroborate my point that if there was an agreement and if they were going to be testifying, subject to whatever constraint, this email would not have been sent. There would not be a pause until we receive additional regarding our involvement moving forward. The involvement is clearly in code at that point. Why would Mr. Wolfe be saying, until we receive additional information from their office, the U.S. Attorney, regarding our involvement? This is just talking about mere involvement. So what happens is I call this the pause email, and it's regarding engagement. So Mr. Jackson on the 20th tried to get matters started. He's communicating to see if ARCCA is willing, if they're ready, if they're able, etc. And then we have the pause. The next tab is tab 2, which is the very important June 10, 2024 excerpt of the transcript. But the time in between, Your Honor, the March 22nd pause email and the 6/10/24 transcript is also exceedingly important. What happened between that? Well, to state the obvious, the trial had started. The trial started in April. Mr. Yannetti gave the opening argument for the trial. Do you recall, Your Honor, that Mr. Yannetti never mentioned the ARCCA experts in his opening?
I
I
did
do.
not review the openings. I reviewed only, for the non-evidentiary transcripts I reviewed, was only Mr. Jackson's closing argument.
Certainly fair enough, Your Honor. Why do I underscore this point? Mr. Yannetti did not even mention the ARCCA experts
They didn't know.
because the defense didn't even know if they would be testifying.
Yep.
The two most powerful witnesses in support of the presentation.
I'm sorry, what was the date of the openings?
I do not know. I do not have it. It was in April. We can hopefully get there.
I can find it. I didn't know if you had it.
So, but clearly, Your Honor, it was between March 22nd and June 10th. And so the most powerful exculpatory information from what we consider some of the most powerful witnesses were not mentioned because the defense didn't even know if they would be testifying. If there was an agreement that they would testify, that would have been in the opening. But the uncertainty about it is the reason why it wasn't in the opening. We didn't know what would be happening. So that pause continued through the opening. That to me is so key because I think it's antithetical to an agreement. Now we come to the June 10 transcript. And as I said, I'm going to hit
We
head
watched
on
that hearing last time.
these areas. I start with, Your Honor, something that's not in the excerpts, but Your Honor will may recall that there were a lot of Rule 14 discussions. And Your Honor, and
I
Mr.
remember.
Brennan read this on February 18th at the hearing we just had, that Your Honor was making the point, which I appreciated, that with this very unorthodox situation, the defense was exclaiming, you were saying, I think you're in violation of Rule 14. I said, we've given everything we've got. We don't have anything more. Well, I know you can't, but you're still in violation. So Your Honor fashioned a remedy.
Mhm.
Your Honor fashioned the remedy, the Rule 14 remedy, that there was going to be a voir dire. And that the ARCCA witnesses were going to have to come up from Pennsylvania and they were going to need to sit for a voir dire. I will get to the significance of that. But that's what started, is the predicate for the discussion I'm now going to focus on.
Okay.
It starts on, this is tab 2, page 2812. Line 5, the court. Now, regarding the 3 experts from ARCCA, so I've read that report. I can't tell who does what or what the basis of their opinion is. So what have you provided? You're referring to the defense, of course. Mr. Yannetti, Your Honor, we provided everything that we know. We mentioned to this court at sidebar, these experts did not arise from us finding them. The court, I understand that. Mr. Yannetti, these experts were hired by the federal government and they provided a report to us pursuant to the TURI request. And it was specifically outlined and ruled that they could not prep with us for trial. Court. And it's important not to stop there with what Mr. Yannetti said. There's more to that statement. There's an elaboration of it that is important. The court. So I'm to believe that the defense is calling 3 witnesses that you've never spoken to and putting them on the stand here. And I want to key into your words, Your Honor, because I want to be fair and precise. Your question.
That's exactly what I said.
Pardon me?
That's exactly what I said.
Yes. And I want to key in on you've never spoken, right? To and putting them on the stand. Now, no one ever said from the defense they never spoke to them. But that was what Your Honor was concluding from what was stated. So what did Mr. Yannetti do in elaborating on his answer? I didn't go back to the video to see if there was sometimes 2 people speak at the same time. I don't know. I'm going to assume it wasn't, and this was just a natural flow. So Mr. Yannetti says that's essentially it. But what follows is really probative. We've spoken to them only for the purposes of coordination of their testimony and their background.
That's what you
I've
said.
got definitions of coordination and background that I won't provide, but those in Merriam-Webster's dictionary have specific meanings. But I don't have to parse that at this point. So I want to continue. We have not been able to interview them regarding their findings, which are outlined in detail in the reports that both sides had. And I know the immediate response might be there. It might be at this point. Wait a minute. You haven't had time to interview, et cetera, et cetera. But what has been the communication up to that point? It's been the first communication from Mr. Jackson.
Yep.
Mentioned in the March 20 email, and then the pause email.
He's saying exactly what I was saying last time, which is that any communications about what they would testify about were after the voir dire, where there was that email commenting on what was spoken about at the voir dire, and then what would be the same or different during the testimony. But prior to that, the only communications were about, communicate, like scheduling, basically how to get them there, whatever. Nothing about the actual testimony and all that. So, yeah.
That statement of Mr. Yannetti, as best as I can gather, is 100% accurate.
Yeah.
It is not merely a response that stops with line 14 to 18. He goes on and explains exactly what the interaction had been up to that point. The statement of Mr. Yannetti is 100% accurate. Now we get to the court. See, I don't see that as being the report. I don't see that as being detailed. It leaves a lot of questions as the gatekeeper as to what they can testify, and you have not complied with your Rule 14 obligations. We can't, Your Honor, and this was what I was pointing to before. So you can't, but you haven't. So I'm left with you haven't complied. So we need to get everybody here for voir dire that can testify yes. Well, we need to do that in advance of their testimony. Okay, that's fine, Your Honor. So the defense is not fighting with bringing them in for a voir dire. That's, Mr. Yannetti says, that is fine. So I said I'm not going to conflate issues, but there's overlap of issues. So here you have a Rule 14 issue. Your Honor has concluded there's a violation. Your Honor has fashioned a remedy. The remedy is they're going to be subject to voir dire. The defense doesn't fight it. That is the Rule 14 remedy. But I'm going to get you how that interacts with the Model Code 3.3A1 in a moment. So we have then
Model Code of
voir
Ethics.
dire. And what I'd like to, if I could, Your Honor, have you turn to tab 3, which is excerpts of the voir dire.
Page?
It's tab 3.
And we watched this last time as well.
June 18,
Okay.
2024, voir dire examination of Dr. Wolfe. And before I get to the specific parts of it, I know this is well known by Your Honor, but it's important to set the predicate for the elucidation of the points I'm making. We all know voir dire is the opportunity for anybody to ask virtually any question they want of the witness to be voir dire. Your Honor set no limitations on the topics of voir dire at all. And recalling Your Honor's concerns, right? I don't know who even is opining on what. I went back and looked at that, Your Honor, pretty fair comment, if I could, from the bench. It was hard to see. But please recall that wasn't the defense's making. We got what was said in cement, the reports. That's the way they came. We didn't create a report that blended experts as to what they were going to say. That's what got dropped in our lap. So the voir dire was the opportunity for the Commonwealth to ask whatever questions they wanted to ask. There were no limitations. So up to this point, Your Honor, I'm going to use some words of others because I'm going to come back to them after we talk about the February 18th hearing. There was no compensation as of June 18th. There was no promise. There was no reward. There was no inducement unless one tries to define inducement as being the hope that you'll get to have these experts testify on behalf of the defense. There was no favoritism, because the Commonwealth had the opportunity to interact with the ARCCA experts. They had the opportunity to call them as witnesses. And we sure know that the Commonwealth knows how to conduct a rigorous voir dire. Please simply recall Attorney Brennan's voir dire of Dr. Russell. That was the opportunity. They had a Dr. Russell opportunity with Dr. Wolfe. What they chose to do with that opportunity, of course, is fully the discretion of the Commonwealth. The Commonwealth did not ask numerous questions that someone with the benefit of my hindsight in Monday morning quarterbacking would have asked them. But I would have asked them a lot of questions, especially given the unorthodox situation and given that the defense quickly jumped on the opportunity, right, to interact and call these witnesses. But they didn't take advantage of that opportunity in the voir dire. They didn't ask those questions. Had they asked those questions, they would have gotten answers. Now, Your Honor, I don't say that that in and of itself addresses the Rule 14 issues. I'm going to get to those. But I want to get to the prejudice, and I want to get to some of the other important issues. I'm going to highlight, because I'm going to come back to it, Your Honor, page 1-67. We heard at the February 18 hearing, and again, I'm going to come back to it when we go line by line for those 9 pages. Not line by line, but many lines. If I could draw your attention, please, to line 12. It starts with line 10 to put it in context. What about human factors? This is the voir dire, direct voir dire. So Mr. Jackson is asking Mr. Wolfe questions. What about human factors? What does that discipline entail? What is human factors? Answer. Well, to give you an example of that, so I do a lot of nighttime visibility work. And then it goes on where, for instance, let's say a pedestrian is coming down the roadway at night. There's also going to be, that I'm going to get to in chronological order, Dr. Wolfe on direct talking about nighttime visibility work, etc. But if Your Honor could just please note the absolute raising of the issue of nighttime visibility in pedestrians affirmatively in voir dire. So that was voir dire, no restrictions, opportunity to ask whatever they wanted to ask. And as a highlight, the voir dire brings out nighttime visibility work. If Your Honor could please turn to tab 4. Tab 4 is the June 22nd, 2024 email but it's important who it's from and who it's to and who's not on. From Daniel Wolfe to Alan Jackson, subject Wolfe qualifications. No David Yannetti on this email. And Your Honor, because I've said it so many times, Mr. Yannetti not being on the email, I can tell you from my own experience in this second trial, but this was, I understand, the first, there was a division of labor. There was a lot going on. This is now June. This is in the middle of trial. Everybody's got responsibility for their witnesses. So there's not collaboration going on. It's not the luxury I usually have at my law firm, where you're sitting in a nice big conference room and all the attorneys are sitting around the table all the time, let's say in March, et cetera. But clearly in June, the trial's going on, but they're dealing with their own witnesses at that particular time. So let's read it because it's short, but it's important. I'll repeat again. This was an email from Daniel Wolfe to Alan Jackson. Alan, I spent this time this morning putting together a brief outline of my qualifications. I've also attached my D&T deposition in the trial parlance. I know it's nothing compared to Andy. I obviously won't say what the response is verbatim, but I gave you a general sense of what my response would be. Again, I thought your questioning during the voir dire was fantastic, so please feel free to make whatever changes you feel necessary. I will try to work on some direct examination questions tonight. So I want to start with, without getting tech-geeky about it, some basics, because these basics were not brought up and I believe led to confusion on February 18th. If you look at the attachments, every email, as we know, has a lot of information on its face, and one of it is you can always tell what goes along with the email. So this is attachment Wolfe Qual's document. But what's the most important points, I think, to be gleaned from this objectively, Your Honor? Mr. Wolfe prepared the document, not Mr. Jackson.
No, I was well aware of that.
Okay, so he prepares it. He sends it along to Mr. Jackson. And it's on qualifications. The next is, if you would just please turn to the attachment, which are the qualifications, et cetera. There's a comment, and these pages aren't numbered, but the questions are. If you look at 19, nighttime visibility work. And there was a comment, and this was referenced on the 18, but I'm going to come back to this. If you don't want me to say that, that's fine.
But he does say it. We covered that too.
That very testimony and that very point was elicited by Mr. Jackson on the direct that we're going to get to. There was no hiding of it.
I read that as well.
Good. Thank you, Your Honor. The next tab, and of course, it has the D&T of Dr. Wolfe's experience in testifying in court, et cetera, et cetera. I will indicate, Your Honor, that the information in terms of quals, et cetera, all of that, to me, would be basic questioning in a voir dire. But those questions, to the best of my knowledge, were not an issue of concern for the Commonwealth with regard to voir dire. I mean, inquiry, but again, that's what voir dire provides the opportunity for. So next we have tab 5. June 23rd is Sunday at 2:59 p.m. from Daniel Wolfe to Alan Jackson. Subject Wolfe direct, attachments, Wolfe direct. So it's clear. And then if you turn the page, that is the attachment, is something that has no labeling on it, but I don't think anybody is going to misunderstand that this is what's being referred to in the attachment Wolfe direct. So all the topics that are in this direct were all in the report of ARCCA. The frozen in concrete report of ARCCA.
Okay.
And we will get to this, but what I did was I went and compared this outline.
I did too.
So to me, this is getting to the thing of like the substantive communications, right? The rule was no substantive. And part of the question was this communication after the voir dire, where they're discussing his testimony at the voir dire and like the D&T questions and all that. Was that substantive or not? But if everything that was in there was in the report, I would say that's an easy no, right? Because the report is the report and that's totally fine. If it was nothing additional, I would say then, yeah, that does not count and they were following the rule. So see.
Your Honor, there's one thing I've learned in the short time I've had in this courtroom is that Your Honor is on everything. And the reason I am underscoring this is because it's going to come to an application of all the legal principles. So I very much and genuinely very much appreciate that Your Honor has, seems like with an exacting eye gone through and looked at all of this. So all of this is what's in the report that everybody already has. Why do I make that point? Because the rule 3.3A1, it has relevance, but it's got more relevance to the rule 14. And we heard on the 18 a very long buildup in an emphasis on the Commonwealth not having access to information, being surprised, et cetera, et cetera. So the point here is, additionally, if you compare the direct examination that actually occurred with this outline, there's not a very close resemblance. The topics are covered. I make that point because of two things. First, Mr. Jackson did not prepare this document. One of your questions at the February 18 hearing was, what's the day, et cetera, et cetera. And I'm going to get to it, and I'm going to use words, not characterizations. That's why I don't want to go into it too much here. But there was a certain impression made about who had prepared this document. But I want to underscore it was Dr. Wolfe who prepared it and sent it to Mr. Jackson. Now I want to get to the timing, because I think this is very important for the Rule 14 issue. This is Sunday, June 23rd at 2:59 p.m. The trial resumed the next day, which is going to segue me eventually to tab 6. And if Your Honor would look at the first page on tab 6, it's June 24, 2024. The very next day, probably less than 24 hours after this outline goes to Mr. Jackson, Dr. Wolfe is on the stand. If anybody thinks that Mr. Jackson was waiting for an outline from Dr. Wolfe to be able to prepare one of the most important direct examinations of the trial until he got it,
Right.
I think that person would have to have quite a fanciful imagination.
I don't think there's anybody here who thinks that.
Thank you.
Fancy.
So the other important point to underscore is that this was something provided by Dr. Wolfe, not drafted one word by Mr. Jackson. So if someone is to say that, and I'm not inferring Your Honor, but someone else might want to infer to say that this is a blatant Rule 14 violation, this should have been turned over, et cetera, et cetera. What happened the next day, one day later, that would have required Mr. Jackson in the middle of trial with an unorthodox situation, trying to figure out what to ask Dr. Wolfe, under what parameters, under what constraints, et cetera, that he should have also had the thought, oh boy, I got this in at 2:59 p.m. on a Sunday. I better hurry up and communicate with the Commonwealth and go provide that to him so I comply with Rule 14. I'd like to believe that I'm very diligent about my Rule 14 obligations, Your Honor. I'd like to believe I would have done it. I don't believe I would have even thought of it. It came to my mind. We know what the standard is, but I want to underscore the connection in time between Mr. Jackson gets this and when Dr. Wolfe is on the stand, because that's really the prejudice time period or potential, if you will, that occurred. Not even to bring in the voir dire, that this could have been brought up, all these topics in the voir dire. Not that voir dire satisfies all Rule 14 obligations, but the reason I brought up Your Honor's Rule 14 remedy was it was the remedy, I think, perfectly tailored to the situation to basically say, I don't, as the court, understand. These folks haven't gotten what the court found was their proper discovery. We're saying we don't have, the information to turn over in terms of we got the report, and all we had is emails in March, right? That are, in my view, not substantive. They're communications. They're Rule 14 material, no doubt, Your Honor. But the question is, what's the prejudice from not getting those emails in light of the voir dire that Your Honor ordered? We'll get to those under 3.3A1, but under Rule 14, they clearly are of no prejudice to the Commonwealth. So now we have the trial testimony of Dr. Wolfe. I mentioned, Your Honor, about the nighttime visibility issue because much was made of that in
There
the
was
hearing
much
one week
about
ago.
that.
If Your Honor could please turn to
Freaking Brennan.
page 3665, starting
Happy Annie, happy to see you again, my friend. Oh, we've been going strong. We go hard. We go hard here with the Squirrel Crew for sure.
at line 22 at the bottom. Question. Mr. Jackson, this is direct. Mr. Jackson is eliciting this testimony. Remember the comment, I don't know if you want to bring this up? Mr. Jackson now is eliciting this topic. And how many of those 1,000, I know you don't have a number specifically, but how many of those 1,000 would you say involve pedestrians as well? Answer, several hundred. As I mentioned earlier, you know, a great deal of my work is in the field of lighting and visibility, so there is a direct correlation between time of day and pedestrian incidents. Here's the key sentence. We see a rise in the evening and night hours just due to drivers having a difficult ability to try to perceive and recognize individuals. So I certainly see a lot of pedestrian collisions in my casework. Elicited, discussed. Now to some very important communications on direct. If I could ask Your Honor to turn to 3669, please. Line 9. This is again by Mr. Jackson. At the time you did your expert review, Dr. Wolfe, and your consultation, you and I had never met. Answer, that's correct. 100% true. You did not know who I was. I did not. 100% correct. You had never met Mislead? No, that's correct. Mr. United? No. Fact. As a matter of fact, you had never heard of this case. That's correct. Page 3670. Line 10. Question. When did your analysis and conclusions, well, let me ask it this way. You finalized your report, you and your team, correct? Answer correct. Question. And that report is contained in a multi-page document that was submitted following your analysis and your opinions and conclusions, right? Answer correct. The defense didn't have anything to do with that. That's correct. True statement. You had never met us, didn't know who we were when we did this. Correct. Now, if you could continue on, Your Honor, to, I believe, if I could be so officious and say this may be some of the most key aspects of the testimony for Your Honor's inquiry. 6. Question. All right. It goes without saying, I'm going to ask it anyway. You haven't been paid by the defense. Answer. You have not paid us anything. No. 100% correct. And you don't work for us. That's correct. There was no engagement. There was no engagement letter signed. There was no retainer. Those discussions that were started on March 20th were paused through the March 22nd email, and they never were re-engaged. They were never re-engaged. They got to eventually get them on the stand, but there was no retainer. There was no terms of the engagement. That's to my knowledge and my review of all these facts and discussions with counsel.
So this sounds like to me, even if it does get to the point where they were paid after the trial, that the point would be still that they didn't know they were going to get paid. Like that was maybe something, I mean, I don't know, maybe we'll find out, right? Like after the fact, it was like, here, you know, we should pay you, but like they didn't, that was not agreed ahead of time. And at the time that they testified, they were not expecting anything. It sounds like. We'll see.
Counsel. So then the next, that's correct.
That's funny.
Question. As a matter of fact, I've never asked you specific questions about your testing before today. That's correct. Mr. Wolfe sent in questions that he proposed Mr. Jackson ask, but that's why I underscored so many times the fact it came from Dr. Wolfe to Mr. Jackson. It's not Mr. Jackson asking questions in that document. It's Dr. Wolfe sending them in. And Your Honor, I'm going to speculate if I could, and I'm not going to do this often in my presentation, but I do know a fact, and I do know, and a fact I know secondhand. If we put ourselves in Dr. Wolfe's position, we think it's odd for attorneys. Imagine him. He's about to sit on the stand in one of the most visible cases in the country. He is an experienced expert. He's used to interacting with attorneys. He is not having the level of interaction and preparation anywhere near what he's used to having, but he's got to go on the stand with his professional reputation, and he's nervous. He's nervous. So my speculation, he sends in the direct to try to get some degree of comfort.
So with all due respect, please don't speculate. Let's move on to the merits. You can use this maybe at argument at some point, but let's just focus on what we have.
I will do that, Your Honor.
Okay.
If you know for certain that's the case, that's fine.
I will tell you, and first of all, I appreciate what you said, and I won't speculate anymore. I said I was going to make an exception.
Yeah,
for
that's
the
a great
fact.
point. Happy Annie says they had to know they're getting paid. I still don't think they knew who'd be paying. Absolutely possible, because we've all been thinking this the entire time, right? Like, and thinking like potentially that they were paid by the DOJ because they were still hired by the DOJ. They were still working for the DOJ. And so that's entirely possible. And that would still make those statements true, right? That they hadn't been paid by the defense and they weren't hired by the defense. Those statements would still be true, even if after the fact they went through the terms of engagement and stuff. And then the DOJ was like, no, we're not paying. And then, you know, and then maybe that's when the defense paid, potentially.
No more, because you said you might do it more than once. So no more speculating. But if you know for a fact that that's true, I'll hear it.
Your Honor, first of all, completely understood. No more speculation. There will be no more speculation until we get to February 18, what I think is really important.
Okay.
Because the Commonwealth on the 18th speculated a lot. And I think the only way to fairly.
So let's
Yeah,
go back
that's
to this.
true.
Okay, you'll get to February 18th.
That's true. Brennan speculated a ton. So let's be fair, Bev, although I know that's not going to happen.
Do you know for certain that that's what Dr. Wolfe was thinking?
I will tell you the basis of it. In fact, I've spoken with Mr. Jackson, and Mr. Jackson said that Dr. Wolfe was anxious about the fact that he had to get on the stand without having the typical level of preparation and knowing. That is Mr. Jackson's sense of Dr. Wolfe's situation at the time the direct was sent. So can I say for certain? No. Can even Mr. Jackson say for certain? No. That's the sense, though, that was extant at that particular time.
Okay.
So we then go down to the next question. But I want to come back to that question on 12. As a matter of fact, I've never asked you specific questions you're testing before. That is correct. That's an accurate statement, Your Honor. That's an accurate statement. 15, your work product, the report that you provided was provided both to the defense as well as the Commonwealth. Is that right? That's my understanding. Yes. And you were equally available to both sides in terms of them reaching out. Correct. Yes. And I called you ultimately after receiving your report and asked if you joined us and testified. Correct. That's correct. Why do I point that out? Because it's not only my sense when I said earlier that and I don't think this is disputed, the Commonwealth had equal opportunity to contact ARCCA. That was Dr. Wolfe's sense as well. So that is the direct testimony of Dr. Wolfe. And I want to just speak to the findings because on page 3676 to 3677, because the findings never changed one iota from the report ARCCA issued in February to Dr. Wolfe's testimony. There's been a lot of talk about potential cause and effect of the interaction Mr. Jackson had with Dr. Wolfe before he testified. And the key emphasis, and I think should be the key concern of everyone, certainly was the concern of the U.S. Attorney's Office in the federal investigation. They didn't want those findings altered in any way. And the U.S. Attorney's Office basically said, we don't want any more additional testing. We don't want anything. You're going to get these findings and you're going to deal with the findings that they have. So what were those findings? Bottom of 3676, line 25, did you perform an accident reconstruction? Specifically focused on determining whether or not damage to the Lexus was consistent with hitting Mr. O'Keefe. Answer, yes, I think that's a fair characterization. And reversing that, was your accident reconstruction also focused on whether or not the injuries to Mr. O'Keefe were the result of being hit by a vehicle? So it's important to know in terms of, whatever the interactions were and whatever the effect of the interactions were, is that the findings always stayed the same. And what was elucidated at trial, what was presented to your court, was not anything whatsoever different from what was established in cement in that report in February of 2024.
Right. Again, that goes
so now we go to, and of course, the findings of ARCCA being that the vehicle did not come into, Ms. Reed's SUV did not come in contact with Mr. O'Keefe, and the injuries that Mr. O'Keefe incurred were not the result of an interaction with a motor vehicle. So now we go, Your Honor, to the tab 7, which is the invoice. I am going to be very precise and point out some items, hopefully for an efficacious purpose. It says at the top, ARCCA invoice date, July 12, 2024. Of course, by then the trial is over.
Okay. And that's the invoice date. Okay, so that's new information. We did not have a date. July 12th, 2024.
Your Honor correctly noted in your preparatory statements about these line items that are in it. We don't run from one word or line in this invoice. But it's important to understand the facts behind this. The last discussion that any member of the defense team recalls having about any compensation at all was back in March. And it wasn't even any discussion about particulars, et cetera. It was just the defense feeling that they were going to be calling these witnesses. And there was the question of, is there going to be, and I had that as required in there for a reason, because they didn't know. It was just trying to understand this very unorthodox relationship because of the U.S. Attorney's Office, their constraints. The defense position is that there was absolutely no meeting of the minds that ARCCA was going to be compensated by the defense. It would have been a surprise if that would have been demanded of the defense. Here we go. But those were paused. Those discussions were.
There we go. That's to your point, Happy Annie, as well there, right? That they did not expect to get paid by the defense. And Heather, or not Heather, oh my God. I said Heather because Roll is addressing Heather here. But the thing about, I also like how he talks. The thing is this is important, right? The thing is that the allegations made by the defense here and the representations they made were very serious. And some of them were easily proven wrong. Like, for example, the shit about, the pedestrians at night and stuff like that. But others of them, we just didn't really have that much information. And Judge Bev got super fucking pissed. And she was like, this could have serious repercussions for the defense and whatnot, right? So this is really, 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 really important that he goes through this step by step. If he just simply got to his point, quote unquote, and didn't show his work as to how he got there, it wouldn't mean anything. He has to go through all of these communications in the timeline, right? Because the timeline matters so much here. So I think it's really, I appreciate the systematic approach. It's very linear. It's very easy to follow. And it might take a while. But that isn't because he's being disorganized or wasting time. It's because there's a lot to have to go through to show exactly what happened here. And it's really fucking important, right? Because if he can't do that, potentially it could be something like Alan Jackson's removed from the defense team or who knows what, right? I don't think it's going to be, not that experts can't testify, but it could, I think the repercussions would really be more in regards to Alan Jackson. Yeah, you didn't realize how much shit he had to dress, right? Heather thought she was a troll again. That's funny. Yeah. There's a lot. It's, when this first happened, people were freaking out. Like, could the ARCCA dudes be removed and not allowed to testify? And Alan Jackson removed from the case? Because when Judge Bev says, huge implications on the defense, and she was all mad and shaking, it's like, oh God, right? And Tonka saying this is how it should be, unlike what we see in Moscow, for sure. Welcome again to you as well, Tonks, as I sometimes say. So yeah, I do, and he's very easy to follow, which I love as well.
And again, that's the recollection of the defense. And to be
Very
clear,
logical.
Your Honor, as Your Honor knows,
Very
I was
logical.
not a participant in the first trial. I'm not speaking with firsthand knowledge on any of this, but I have conducted as thorough an investigation of these facts and marshaling of them as I think I can possibly do. So here's the punchline, Your Honor, with the invoice.
Uh-oh.
Came out of the blue. It came out of the blue.
Oh.
It gets sent to Mr. Jackson's office in July.
Oh.
I can't reveal attorney-client communications, but I can tell you there's one person that was more shocked than most about the invoice coming in and the amount.
Interesting. So they were not expecting to pay them. Interesting. So I wonder if it was a thing where like because of the DOJ saying we're pausing it, we're not going to I wonder if everybody, including the ARCCA dudes and the defense team, thought the DOJ was paying them. And that's what we all thought. Right? Interesting. And then this came out of the blue. So maybe the DOJ said, no, we're not going to put that bill, and then had the bill sent over to them. And if so, you can see why they would have been surprised and maybe a little bit pissed, not at the ARCCA dudes, right? But maybe at the DOJ, rightfully so, right? Crazy. Oh my God. Let's not be stupid. Okay.
What happened? And this is, Your Honor, objective.
By the way,
These are recollection.
I said let's not be stupid, by the way, to the YouTube, because it on full screened me. So yeah.
Information. The defense team called Mr. Adam Deitch at the U.S. Attorney's Office.
Oh,
What is this?
here we go.
Can we pay it? We supposed to pay it?
Oh my God.
I encourage Your Honor to communicate with the U.S. Attorney's Office about did this conversation really occur? What was the substance of the conversation? Because as I understand it, one of the questions of Mr. Deitch was, can we pay this? Are we going to be in violation of some expectation of yours? We want to do this the right thing. Mr. Deitch said, yes, you can pay. Why would the call go into Mr. Deitch if there was a prior agreement that they would be paid for anything?
Yeah, I think
There would
it's
be no
clear.
reason for the call.
That's clear. Okay. Now that makes sense. Wow.
Did they pay it?
Yes, that was just the point I was going to get to.
And when was that?
The best of my understanding was very close in time to when it occurred. So I understand the date of this invoice, not understand. The date of the invoice is July 12th. And I think I can get you the exact dates here. Mr. Jackson's firm, not Mr. Jackson, but a staff member, and I want to be careful of attorney-client communication, so I'm not going to talk about the substance, but communicated to Ms. Reed that this invoice had come in. And I believe that communication was toward the end of July, maybe I'm going to roughly estimate the 24th. And then there was a communication, of course, with Mr. Deitch. And after Mr. Deitch said, yes, it's permissible to pay that, I believe the payment was made very shortly thereafter, maybe within a week.
When was that? Within a week within that July 24th date?
Get you an exact answer?
I would like that.
Sure. I'm going to attempt to get an exact. If I can, I think I can get a good approximation.
So,
Your Honor, I understand a check was sent to ARCCA on July 25th.
Thank you.
You're welcome.
so it could still be that there's a discovery violation here if they didn't turn that over. But it's not, right now it's looking like it's not nearly as bad as it could have been, in the sense that if they'd been misrepresenting something at trial before the jury or before the court, that would be a problem. And it looks like that wasn't the case. So we'll see. As far as
So there's no doubt the invoice was paid. But the story is not solely about was the invoice paid. The important part of the story, about the facts, is it came out of the blue. And I don't expect anybody to take my characterization 100% But that's my full understanding. But the call to repeat to Mr. Deitch is, to me, the corroboration of that very point. And it's an
Well,
important,
if something's blocking you, it's not me. It must be something with YouTube. I'm not blocking anything. I only block
it's an
Glenn.
important question, and it's important, very important question. But it's an important fact point
Oh, no.
as well that call was made. So in terms of the next tab, which I've been alluding to during
Okay,
my,
so this is the one I said I needed to take a
I
recess
was
to
just
read
going to
that.
say the same thing.
All right,
This
so-
is now that point.
All right, why don't we take a 15-minute recess?
All right.
Okay, I will
You
say,
unmuted.
well, I skip ahead here. I will say, sometimes YouTube will block comments even from me if I type in the chat, any chat, but this even on a live stream of mine. Sometimes they're completely benign and it just gets it wrong. So I don't know, but that's a YouTube thing. I have no control over that. I mean, I can't block chats anyway. The way it would happen is you can just remove a comment after it comes in, but I can't block them. I can't block them preemptively. I don't want to anyway. You can only block people, like fun. Well, now we have the only fan, but also the lights. So now what they took the break for, was for Judge Bev to read the transcript of the hearing from last week. And my thought is so that she can hear what all Brennan represented to the court. That would be the point of that, right? And if anything, what she should find is he was completely misrepresenting things. Maybe he didn't have the dates for the invoice, but a lot of what he did represent, we were able to impeach him on ourselves just by going back to the hearings. And he said he didn't watch them. I don't really fully believe that, but he did say he read the transcripts, and the transcripts alone would have given him enough information to where he should have, the only way he could have said what he said was misrepresenting things. And the other thing too, is then there's the whole thing about where he said the defense, or he had to go get discovery from the feds through TUI, and that like the defense didn't turn shit over. And then he kind of made that correction later, but he did that in a Weasley way where he didn't do that how he should. He should have fucking groveled, and he didn't. So
You are unmuted.
Put it back in session.
May I proceed back to the podium, Your Honor?
Please.
Would you like to remain seated?
You can go back.
what's in the comment settings? I don't have
May
any.
I continue, Your Honor?
I don't have any filters on at all. I have no filters.
So, Your Honor, to blend and quickly summarize what we've gone through, I'm using the table of contents of the notebook. We've spoken about the March 20 and March 22nd email from Mr. Wolfe to Mr. Jackson. We talked about June 10th and statements of counsel. We talked about comments of Your Honor. June 18th, we've talked about briefly the voir dire of Dr. Wolfe and the opportunities the parties had there. We talked about the June 22nd and June 23rd emails from Dr. Wolfe to Mr. Jackson and the proximity of those emails to the restart of the trial on the 24th. The 24th is the trial transcript of Dr. Wolfe, July 12th, the date of the invoice. As Your Honor well knows, we got you when that invoice was paid. And now with all of that, what I am going to do, Your Honor, hopefully productively, with no speculation.
Okay, so you don't have to tell me what you're going to do. Just go ahead and do it.
I'll just go ahead and do it, Your Honor. Now to the transcript. And as I go through, I start on page 53.
Okay.
Line 19. And this is Attorney Brennan. Your Honor, my purpose is not to deprive the defense of an expert. I'm going to stop there. That statement is I will carry forward about the Commonwealth's statement that they're not seeking to deprive the defendant of ARCCA as a witness was made 5 times. I counted them and I'll go through each one and number them. Or deprive the defense of an ARCCA expert in this case. Very important, because from my perspective, what was put in the firing line on February 18th was the ARCCA experts, albeit indirectly. So now we go to page 54, and this is going to be, in some points, a line by line because the words matter. Line 5, and this is again is Attorney Brennan.
Mm-hmm.
Well, what the government worries about is that there is other things that are relevant, like compensation, promise, reward, inducement, whether there's collaboration between one side or the other, and that expert witness that they don't know about, and can't ask about. I'm going to stop there. That they don't know about? Really? Don't know about the ARCCA experts? February 12th report? Of voir dire? Knowing the purpose of the voir dire was we wanted to have these witnesses testify. And then the next statement, and can't ask about? Really? Can't ask about? Voir dire, the opportunity. Next statement, that there's some bias or favoritism that the expert might have towards one side for whatever reason. I don't know what's meant by favoritism, but having worked with experts almost every week, you call an expert to testify. I don't know if I would call it bias, but I don't think it's a stretch to say that if an expert's going to come in and give opinions helpful to your client, that that expert is biased. But this expert was not engendered by the defense. It was engendered by the U.S. Attorney's Office in their federal investigation. Next, on line 12. So that if that information is not disclosed, really? It was on February 12th of 2025. Now I'm going to get to this because, and this is not speculation, this is fact, the entire buildup of February 18th was on the false foundation that the Commonwealth had gotten all the information that they were going to talk about until Your Honor's break from the federal government and not the defense, which was completely false. So this is a buildup. It's all in.
And what was the date again that the defense provided it? The Friday night before our hearing, was it?
It was, I will tell you this, I'm going to have to think out loud here. I'm going to answer it. I think it was February 12th that it was provided of 2025, but it's important to state why that date. Please recall, Your Honor, that the Commonwealth had not yet issued its certificate of compliance with discovery. And I know I don't need to tell Your Honor the rest, you know it better than I do, about counsel's obligation to turn over discovery, et cetera, et cetera. So I don't know if the Commonwealth on the 18th genuinely didn't know that it came from the defense as opposed to the Commonwealth. But what's very, very clear are the statements that I'm going to go through that were all built upon the foundation that they learned about this all from the federal government and that the defense had not turned over anything which is completely false. Okay. So let's go through each word because it gets really important. When there are claims made that the defense has not turned over something and there are words used like ambush and duping, it's important to understand and get behind those verbs as to what the facts are. So the next. So if the information is not disclosed, then it's not only an impediment, it creates a position where there's an unfair examination. Really? Voir dire occurred? It's not the ARCCA witnesses that I have the issue with. That's number 2 of 5. The Commonwealth is not saying we have an issue with ARCCA. And why do I keep repeating this? Because my conclusion is going to be ARCCA should be unscathed. ARCCA should be available to the defense. And I'm going to get to more of that in a moment. So it says it's not the ARCCA witnesses that I have the issue with. It's the issue, the fact that I don't have adequate discovery. Those words, I don't have. The Commonwealth had, for 5 days, the very discovery that was being discussed that the Commonwealth didn't have. If the defense is going to be a proponent of those witnesses, they have obligations, Rule 14 obligations for basic discovery. I agree with that. I agree completely with that. And we complied on the 12th. And it's for this trial that matters, Your Honor. Your Honor has commented before that this is a new trial. This is a second trial. I tried unsuccessfully sometimes to talk about the baseline with the Daubert issues, and Your Honor has rightly commented, well, Mr. Alessi, this is a new trial. Point taken. Now, I wasn't at the last trial, but I've read the transcripts. That's an important point, Your Honor. Mr. Brennan has said before that he, earlier in these pretrial proceedings, that he hadn't had a chance to watch, hadn't had a chance, and believe me, I can empathize with Attorney Brennan on that. It's a lot to digest. He and I are both coming into this second trial new. So I appreciated the comments he had made before, but his comment here is I've read the transcripts, and I'm going to assume that for the very important topics he was talking about, he had read the transcript.
Oh my God, he's making the point I just made, which is that even if Mr. Brennan had just read the transcripts, he should have known that things he was saying were easily disprovable, and he was misrepresenting them anyway, which is interesting. That's the point he's getting to here. Because the transcripts, whether you watch it or you will read the transcripts, you can solve a lot of the things the questions he was raising or allegations he was making, you can completely dispel those on your own quickly, you know?
But again, that would be something that only Attorney Brennan would know. But it's an important point to point out. That was the representation.
Compton, Long Beach, Inglewood.
The transcripts. And then he goes on, and on page 55, he repeats what we went through about June 10th and what counsel for the defense had said. So I'm not going to cover that. He's just reading what I took head on before the break. And so we then turn to the continuation of the buildup, which is at the bottom of page 55. Attorney Brennan. Now, I have some familiarity with the federal government. Seemed to me, based on my limited experience, there was much more to the story. And the story is about interactions with defense counsel. That's what was talked about above. So I called the federal government. There's no statement here. There's much more to the story. And I've got the discovery that the defense provided.
Here we go.
It told a complete story. So there was, and I'll tell you my impression from what was stated here.
Okay, so the question that a lot of people have been asking up until today is, did Brennan intentionally lie about this discovery, or did he make a mistake? And some people, it's funny, some chats have been voting on it. People have been maybe saying one thing and then they change their mind. Because the thing is that if he did it intentionally, that's so risky. It's so risky, especially when he would have to know that the truth would come out. And he would have thought it would have come out that day. He had no way of knowing that Judge Bevel was going to end the day early, right? You know, they had that break and then he came back and just was like, oh, he didn't even say there was a mistake. He was just like, I just want to clarify a timeline, right? And so, but even if he hadn't done that, like, the defense would have clarified it, right? He didn't know it was going to end the day. And so to me, that makes it seem like it would have been a mistake, right? And again, he still didn't handle it properly because he should have been groveling and he should have come in and said, I made a huge mistake. I didn't mean to misrepresent this. I didn't realize it. I just saw it when we were taking a break. I found, X, Y, and Z. And I didn't, he should have made that clear. But I just wanted to point that out because this is what he's about to address right here. And this was something that was a huge deal. That was, again, not addressed correctly at the end. He didn't handle it the right way, but at least it came out that the defense had turned those things over. So
is that counsel made these representations, but the Commonwealth couldn't evaluate them because they didn't have information. So they went to the federal government. So I called the federal government and I tried to encourage them to provide full discovery so that the experts could testify.
I know nothing.
Another statement, so ARCCA could testify.
No.
I was resigned to a Dewey letter. I've been down that road many times. It's a dark road that never sees the light of day.
Right.
So I filed a Dewey letter, comprehensive Dewey letter. And it was delayed. Right. And over a long period of time with requests and deadlines, I finally received a response that was unresponsive. This is talking about discovery and information about ARCCA that was already in the possession of the Commonwealth. And it was striking that it was noted it was unresponsive just when I read the materials. I don't know which materials Attorney Brennan is talking about. I'm going to give Attorney Brennan on this one the benefit of the doubt.
There it is.
He's not talking about the discovery materials that we had provided because.
Okay. Yep. So here it is. This is exactly why I brought that point up. However, the fact that he just quoted from the transcript of the hearing, and the fact that it reminds me now with the way that Brennan had said that they got a response that was unresponsive would mean that he should have known the discovery was from the defense even at the time he said that, which was before he corrected it. Because if they didn't turn anything over, then obviously everything you have is from the defense. That's probably why some of the people were saying it had to be intentional. This is crazy. What's going to happen?
I think fairly read in context, that's not what he was referring to, but I don't know what's being referred. It's not the point I wanted to make. And Attorney McLaughlin actually identified them. They didn't respond to our request, so Attorney McLaughlin wrote back. And then we got new materials, just some. Got them from the federal government. It's not a statement that he got them from the defense, which is a fact. And then we got new materials, but it qualified, just some. But these materials were the very reason why the defense should not be able to call witnesses without giving full discovery. We had given full discovery. We had given it. Having not been at the last trial and reading the transcripts, I only have a flavor for the last trial. So there is email correspondence between the defense, not only the federal government, but some ARCCA, the witnesses themselves, and recent requests for. So saying, this is what I got from the feds. And what do I discover? When I got this information from the feds, when he really got it from the defense. There's email correspondence between the defense, but not only the defense and the federal government, but the ARCCA witnesses. And then he goes on. But if we look back earlier in the relationship, what we see back in March 22nd, 2024 is that there are conversations between the defense, Attorney Jackson, and Daniel Wolfe, who's one of these ARCCA witnesses. And then he goes on and he reads the email. But the clear import of the point here is that the Commonwealth is saying right here that this is when I discovered these emails. This is how I got them, not from the defense, but the federal government.
I'm laughing because you guys are really funny. I'm going to back this up because this is really fucking important. But that's really funny. Strip violin. That could be a thing. Maybe there's like an untapped market there. You know what I mean?
Correspondence between the defense, not only the federal government, but some ARCCA, the witnesses themselves, and recent requests for. So he's saying, this is what I got from the feds. And what do I discover when I got this information from the feds when he really got it from the defense? There's email correspondence between the defense, but not only the defense and the federal government, but the ARCCA witnesses. And then he goes on. But if we look back earlier in the relationship, what we see back in March 22nd, 2024 is that there are conversations between the defense, Attorney Jackson and Daniel Wolfe, who's one of these ARCCA witnesses. And then he goes on and he reads the email. But the clear import of the point here is that the Commonwealth is saying right here that this is when I discovered these emails. This is how I got them, not from the defense, but the federal government. And we know now that that's incorrect.
Yep, there it
Then we
is.
proceed down to line
There it
page
is.
57. The Commonwealth, as I understand it, was not aware of any promise, rewards, or inducements or payment. They relied on a reciprocal discovery order of this court for that information. That's a misdirection. That's a misdirection.
Yes, it is. Like I
There
said,
was no promise, rewards, or inducements or payments before all of those documents
you
that
guys.
the Commonwealth is referring to here.
That's really
That
funny.
didn't come until the invoice
That's
came
a
into law.
reference to.
And it wasn't even a promise. It was pursuant to the conversation of Assistant U.S. Attorney Deutsch that, yeah, you guys got to pay it, and it's okay to pay. So next, on page 57, line 11, he reads, response, hi, Alan. Subsequent to our conversation on Wednesday, this is, I think he's reading from the March 22nd, but one of the disquieting aspects of this February 18th discussion is it's not chronological, doesn't have dates. So it's kind of hard to follow, but it certainly gave the impression, clearly, not the impression, it was stated that these came from the government, and I'm going to get to it when Your Honor was asking very apt questions about dates. But this is a very interesting paragraph. Hi, Alan. Subsequent to our conversation on Wednesday, the U.S. Attorney's Office asked me, are there any further conversations? Did we receive additional information from their office regarding how our involvement will move forward? Your Honor, I'm going to please ask you to turn back to tab 1.
Back to tab 1 we go.
Because this was a purported quote of the March 22nd email.
Reported.
That's really not close to what the email says.
Wait, I want to hear how it was represented again, because I hope Brennan gets fucking roasted the fuck out of for all this.
To please ask you to turn back to tab 1.
Didn't go back far enough.
Gave the impression, clearly, not the impression, it was stated that these came from the government, and I'm going to get to it when Your Honor was asking very apt questions about dates. But this is a very interesting paragraph. Hi, Alan. Subsequent to our conversation on Wednesday, the U.S. Attorney's Office asked me, are there any further conversations? Did we receive additional information from their office regarding how our involvement will move forward? Your Honor, I'm going to please ask you to turn back to tab 1 of my notebook.
Did he
Because
for
this was a
real?
purported quote.
Did he for real completely? Okay. Okay. I'm gonna, if Brennan actually, because I remember that, right? If Brennan actually said, here's the email and read it, quote, right? I remember him doing that. But if he did that and the quote was incorrectly stating what was in the email, like he literally read it as if it was like the literal email and it was wrong, there's no way around that except that that would have been intentional. And now we have an even bigger problem. Oh dear. For Brennan, I mean.
Of the March 22nd email.
That's funny to us.
That's really not close to what the email says.
Oh dear. Brennan. Why'd you do it, Brennan? You're gonna should get in trouble. Dude.
It's not totally incorrect, but here's what I'm going to do, Your Honor. I'm going to assume that the court reporter's transcription was not accurate and Mr. Brennan accurately, because I'm going to give Attorney Brennan.
Oh my God, you guys. Fuck. You hear what he's saying here? He's saying the only other possibility besides Brennan intentionally misleading the court, like in a big way, not just like misrepresenting, but completely misquoting something. He's saying that the only way that that's not possible is if the court reporter made a mistake. And here's what he's doing. He's saying, in order to give Mr. Brennan the benefit of the doubt, we have to essentially blame the court reporter. And you guys know which one is more likely. Holy fuck. Dude. Oh, man. Let's listen to that again. Oh, my God. Wow. Wow. That, to me, is so much more impactful than actually trying to throw Brennan under the bus, because now he doesn't have to do it, but he's made it blatantly clear and highlighted. And now it's like there's no way around it, right? Like, for example, if you're the defense attorney and you're going to try to throw counsel under the bus for the Commonwealth, you know how well is that going to go over with Judge Bev, right? She's going to push back. But, and so is Commonwealth. But this is a brilliant strategy. It's like, look, I'm going to blame the court reporter. And we all know, dude, get it. Wow.
It's not totally incorrect, but here's what I'm going to do, Your Honor. I'm going to assume that the court reporter's transcription was not accurate and that Mr. Brennan accurately, because I'm going to give Attorney Brennan the
Oh
benefit of
my
the doubt,
God.
because I can tell you that I've had my statements in court not completely correctly transcribed by a court reporter, and unfortunately, sometimes it's been on some key things. I don't think this is key at all, but I just note it. But it says, Mr. Brennan goes on, now it's the opinion
Interesting.
that troubles me. It's relationship, and the Commonwealth should have an even playing field. That's number 4 of the time he's not having any trouble with the ARCCA experts. Saturday, June 22nd, Daniel Wolfe wrote, Alan, I spent some time this morning putting together a brief outline of my qualifications, blah, blah, and this is just a repeat of what we have already heard. Here now comes the important points. Page 58, line 2. Now, this isn't information provided by the defense in reciprocal discovery. Oh my. This isn't information. He's talking about all these emails. This isn't information provided by defense in reciprocal discovery. This is information provided by the federal government after numerous requests, jury requests, and an insistence, the best I can to get as much information as I can. It's incorrect statement number 2, and it's an important one. Down below, unfortunately, it gets even more incorrect. Defendant provided an outline of questions and answers for the direct examination. Please put this in context, Your Honor. The Commonwealth appears to be believing that they got the information from the federal government, not the defendant. So they got the outline, and they're now accusing the defense of having essentially drafted the outline. Defendant provided an outline of the question and answers for direct examination. Why? That's not fact.
So that's another one. That's another time where, again, this would point to Hank Brennan intentionally misleading the court, again, as it pertains to the who turned over that discovery. Just like a few minutes ago when he was like, we tried to get more discovery and we got back non-responsive, right? But then this is the second time.
But if that were true, that would be very bad.
So what I'm going to do, I had no idea it's this late. So it's 1 o'clock. We're going to break for
Oh my
lunch. We'll
God.
start back up at 2.
Okay.
Do you think, I have no idea how much longer you're going to be, Mr. Alessi. Do you have an idea? And I'm not rushing you. Do you have an idea? Because we do have the other motions. If we can't get to them today, we'll spend those 2 days next week with them.
Wow.
I'm going to answer your question. I think I can conclude in 45 minutes because I have to get to the law, the 3.3a.
I'm not rushing you. I just wanted a time frame.
Best answer, and I will say this, Your Honor, I share your interest. I'm presenting some of these motions, and I have a strong desire not to be back here for that. So I share the goal, believe me.
Okay, so we'll see everybody at 2 o'clock.
Okay, taking a lunch break.
You are muted.
And they're back. Sweet.
Okay, please, the court. I first want to thank Your Honor for the generous amount of time you're
No
affording
need
me.
to thank him. Just go right ahead, sir. Take your time, Mr. Alessi. I should have cut you off. I appreciate that, but take your time. Mrs.
Thank you. So, Your Honor, I left off with
Right?
page 58 of tab 8, which is last week's hearing.
How is it that the lighting and sound is different than it was before?
And
Anyway,
what I want to do is to go to, because I'm going to go backwards ever so slightly because it's an important segue to returning to page 58. So I referenced the court to page 57, line 11, where the Commonwealth said, response in quotes, hi, Ellen, substance to our conversation on Wednesday, the U.S. attorneys, and he's quoting according to quote, and it is good to have it, Your Honor, can be having tab 1, which is the March 22nd email, because I'm going to compare and contrast tab 1 to where I am on page 57. And Your Honor, I'm sure will recall that I dubbed tab 1 the pause email.
Yeah, so I have them, and rather than me going from tab to tab, I'm going to use my copies. So go right ahead.
Perfect. So I'll just refer to them, Your Honor, as the date because that was best for the court.
Yes.
Okay. So the March 22nd email, I dubbed the pause email,
Yes.
and because of obvious reasons, and it's got the word pause in there. And the pause is a very, very important concept because the pause is the stopping of communications before really things even got underway, before there was even an agreement, engagement, et cetera, et cetera. So compare that, please, to the quote, purported quote on page 57. 11, hi, Alan, subsequent to our conversations, he's quoting reportedly this email. On Wednesday, the U.S. Attorney's Office asked me, are there any further conversations? Did we receive additional information from their office regarding how our involvement will move forward? Your Honor, there's not one mention of the word pause in that quote. The word pause was left out of that quote.
Oh dear.
That is the foundation of that email. And it's not merely semantical, it's the cutting off of communications.
Wow.
And it's unfortunate that that clause was not quoted on page 57. Now back to page 60, or excuse me, back to page 58. And this is where I left off. Line 2, now this is information provided by the defense in reciprocal discovery. This is information provided by the federal government after numerous requests, 2 requests, and in assistance, the best I can to get as much information as I can. Defendant provided an outline of the questions and answers for direct examination. So this is where I left off. That's not correct. There was Dr. Wolfe that provided the outline. It's really important when we're talking about collaboration, et cetera, communications. That's not accurate. And Your Honor, what is important to note, Your Honor asked about when did the defense provide the discovery.
And you told me the 12th.
And I want to correct that. I was off by a date. It was February 13th.
Okay.
Because it's important to try, I clearly understand to be as accurate as we can. I'm the one creating the standard that every word counts, every date counts, so I want to try my best. I may get something.
Yeah, he's like, look, I got a date wrong. I'm going to correct that. Doesn't even really matter, but he's still, this is awesome. Honestly, I actually think it's great. I'm sure this was a mistake, but honestly, it's like, look at here you go. Look, I made a mistake. I'm going to correct it. Wow. Brilliant. I'm happy that happened because it just, boy, what a stark contrast, right?
Wrong, but I want to try my best. Yeah. So what I did during the break is I went and asked for the email.
Oh my God. What I did during the break, dude, this is just like an example of what could have been going on last week with Brennan, and they had that long break and then he came back, and look at the difference. Remember what I said? I was like, even if it was an accident, whether it was an accident, like Brennan did not handle it correctly by pointing it out and highlighting it and saying, here it is, first thing. And that's what he's doing. Incredible.
Sent that request. So it's the email from the defense to the Commonwealth providing the discovery.
Okay.
And the email is dated February 13, 2015 from, I've got extra copies of the court wants it, if the Commonwealth wants it, from Evelyn Arellano, and she is an employee of the Worksman Jackson firm. And it's important to who it's addressed to. 2, the first name on it is Hank. That's the first name on it. To Hank, Mary Ellen, Adam, and 9 more. Good afternoon. The Dropbox link below contains ARCCA reciprocal discovery. Please let me know if you experience any issues accessing the file.
Okay. What time of day? Because if it's California time, it might be different than what we have here. But
It probably will be, but I don't know what time of the day. I'm going to ask the team if they can access what time of the day, because I don't know the answer to that as I stand here.
okay.
All right.
And so it suffices to say that the hearing was on the 18th. So it wasn't like it was a Friday and then we're back in court on Monday. My
Right.
best recollection, the calendar will be the best evidence, is that this was toward the middle of the week, right? But in any event, let's say worst case scenario, it was dispatched at 9 o'clock at night, California time, which would be midnight Eastern time. And let's assume worst case, it's therefore in effect the 14th. That's 4 days before the 18th.
I was literally just going to say she's going to quabble over the time, but I was like, it's not even going to matter. We're talking about days here. The time zone difference doesn't matter here.
That this is sent. And
Do
what
you have a
is-
time?
Pardon?
Do you have a time, Ms. Little?
Oh my God.
Yes, 1 moment.
Thank you.
And I understand Your Honor, letting me pause until you get it.
If we can, just looking at the
Absolutely.
calendar. If you don't, I thought you may have had it. We can move on.
It was approximately 6:30 in the evening. It was received by the Commonwealth,
Thank you.
Is that, may I ask Your Honor, if that's Eastern time, 6:30?
Eastern Standard Time.
Thank you, Mr. Ball.
And Your Honor, it was a Thursday.
I'm sorry.
It was a Thursday.
Okay, thank you.
So also, in big bold letters, at least on the printout, the subject is Karen Reed ARCCA reciprocal discovery.
Wow.
It's not like it was buried what was being said.
Nope.
I mean, this was a lot of things, but it's right there, ARCCA reciprocal discovery.
Was it just these pages that we've been talking about, or was it a lot more discovery?
May I confirm with counsel? I know the answer.
It was just the pages, Your Honor.
Okay, thank you.
So it's not like this, ARCCA is amidst a sea of other topics, right? This is the driving force of the email. And so, Your Honor, the question, and I'm going to keep moving on, but the question becomes, and I'm going to ask it more than once, but hopefully not too much. How is it that the Commonwealth on the 18th understood incorrectly, I think it's undisputed it's incorrect, that they got these materials from the federal government? I
Yeah.
don't know the answer to that question, but I respectfully submit it's an important question.
Oh my God. Let's hear that again. How did they think it was from the federal government? There it is. Dude, Brennan, there needs to be much groveling. There should have been already from him last week, but dude, wow.
And I'm going to ask it more than once, but hopefully not too much. How is it that the Commonwealth on the 18th understood incorrectly, I think it's undisputed it's incorrect, that they got these materials from the federal government? We don't know the answer to that question, but I respectfully submit it's an important question. Was it an honest mistake? Was it just, as happens sometimes in lawyers working together, there's a lack of communication, there's a miscommunication. Is that the explanation? But I think truth and justice on these topics, since we're being so exacting and appropriately so, we should have an answer to that question. So we move on to page, so there we have on page 58, we have another incorrect statement. We have two of them right up off the top. And then we continue on page 59. Your Honor, understandably says the court, what is the date of that? Mr. Brennan, it's not dated.
When I said date, what was I talking about?
I believe, Your Honor, you were talking about the outline.
Just give me a second.
And Your Honor, if I may, I want to give you the second, but the basis for that answer is page 58, line 7, where the statement is, and what follows is all about the outline.
Okay.
So, Your Honor, appropriately and understandably says, what's the date of that? Here's the answer, Your Honor, got.
There is no
It's not
date.
dated. It's
And I was literally thinking this because they had a date for it. We heard that earlier. And he says it's not dated. He said that for a couple things. He said that for the email, and I think that's what he's referring to. The email, which is so dumb. It was a dumb question from her, and it was a dumb answer from him because the email references the voir dire and upcoming trial testimony. I pointed that out myself when I heard it the first time. I was like, obviously that's when this is from. It's obvious. You just have to not be dumb. But he also said that the invoice bill thing was not dated. And again, they provided a date for that bill, but you didn't even need that for this because the date was obvious. But let's just see what he says.
It's not dated. Now, let's please just go back to tab. We're talking about the outline.
Tab 1.
Let's go back to the outline.
Tab 1.
And we can pick either one. I'll pick perhaps the most probative one. I'm not going to refer to the tab because Your Honor says you have these. This is the June 23rd email from Daniel Wolfe. I'm just wanting to make sure you're thinking.
It's what I refer to as a script, right? That's what you're referring to?
That's what Your Honor has referred to it as.
Sorry, that itself is not, I understand it's with email, but it's not dated.
Well, Your Honor,
Right. Okay.
I was going to get to that, but there's context for that.
Okay,
The
Ah,
context, you're correct. The outline.
literally. Okay. So there isn't a date, but there's the context. That's literally what I just said. If you put it into context, it's obvious.
Itself is not dated. However, the attachment,
Obvious.
keep in mind, we produce these materials.
Okay.
So we deal in e-discovery all the time. And when you look at the attachments, everybody relies upon the attachment line, especially if it's a Word document. So it's wolf_direct.docx. So you know this email has an attachment. We fortunately have a file named direct. Your Honor has referred to it as a script. There is no other document that was produced that comes anywhere near close to this being the direct. So I don't believe there's any reasonable basis other than the other email.
How funny though that Bev calls it a script. I mean, it's disgusting, right? She calls it a script where it's just simply the questions that Dr. Wolfe is like, and again, all of them are in the report. It's just a list of sample questions after the what. Crazy she calls that a script. That's disgusting. Yeah, I have it on 1.5. It's really funny because other people were having it on 1.25, and I was like, this he love him, love everything about him. He speaks and probably part of the reason why he's able to speak with such intention, so linearly, so clearly, with everything being just laid out so well, is because he takes his time, right? And so normally I would have most people on 1.25. But I think he's totally fine. At 1.5, I think this is totally, in other words, it took Rollo that long to figure out that it was on faster. That's really funny. The only time it's obvious to me is at times when like they're going to pause for somebody to go find something and they're like, oh, don't worry about it. But then it's like, they already found it. And it's like, oh, because that was probably like 10 seconds elapsing, but not here, not right now. But yeah, if you think it's too fast, I can slow him down to 1.25, but I think he does fine at this speed.
On the quals
When we get to Brennan, I'll put it on 1.25.
came the day before, 2 days before, day before June 22nd, which has the same attachment wolfquals.dcx.
Can I ask a question
Yeah.
because I don't understand? So what I have separately is a script and then something saying qualifying the expert. Is this all one document?
No, Your Honor.
All right,
And I
so
appreciate the question.
What is the date of so you're saying what I refer to as the script was sent?
Yeah, I totally agree. Rolla says he makes your mind picture everything and archive each document. Yup, exactly. To where I even have a visual layout of his book, right? Even when he was like, oh, let's go back to the layout. And I was like, oh, tab 1, right? Totally. I'm 100% he does that. He does a great job of that.
On the 23rd?
That is correct, Your Honor.
What was the other one?
The other one was sent the day before on June 22nd. I'm just going to give the name that the email has. I think it's Wolfe_Qualls document. Okay? So there's two emails. One's just the Qualls. The other, respectfully, Your Honor, I know what you're calling it. I'm just going to call it what it says. The title is direct. So it doesn't matter which one you're talking about. To me, it doesn't matter whether there's a date on the actual
I agree with you, Rolla.
Qualls document or the direct document. We produced them in this fashion. And I believe the only reasonable conclusion is that the outline is what is sent under the June 23rd email. And Your Honor, the reason why I persist in this is because if Your Honor goes and looks at the, and this is important for the context, if you go back to the June 22nd email,
Okay.
the last sentence is, I will try to work on some direct examination questions tonight. So you know that when the direct comes in the next day,
Yeah.
I think the only reasonable conclusion to make is that that direct outline was created after the 22nd or on the 22nd or after,
Obviously.
and certainly by the 23rd.
Oh, God.
So that's what the Commonwealth had in terms of the information. So in conclusion on this point, but I think an important one, it's not dated, but here we go back to, Your Honor, the TURI request is a recent February response, but they, and I'm assuming the Commonwealth meant the federal government, send random documents. There's no real accounting. There is an accounting on the face of the emails.
So actually hold that thought. I just have one other thought.
Yes, please.
So we're talking about Saturday, June 22nd, what was sent as an attachment with the email, and Sunday, June 23rd. So this was before the witnesses testified, right?
That's
You were
right.
saying that this was disclosed prior to the February 18th hearing, but was this disclosed prior to the witness's testimony?
The answer is no, Your Honor.
All right.
The
I
answer
just
is
wanted
no.
to be clear. That's how I see it. I just wanted to give you the opportunity to tell me if that's not accurate.
No, that's 100% accurate, and I'm going to get to that. To me, that's a Rule 14 issue, not a candor to the court issue.
Okay.
Right.
So
Okay.
now if we
So again, that's the distinction I've referenced, is that some of these things might still be a Rule 14. That's the discovery, right, issue. But the candor to the court, that's the whole other thing. That's like the intentionally misleading. That's like where you could get in trouble with the bar association. And so that's the thing that seemed to be really scary last time. Now, again, when you look at it, if anyone's going to be getting in trouble with the bar association, it should be Brennan, I think. So far, I've not seen anything to support that there was any intentional misleading of the court on behalf of the defense. So
could please go back to page 59.
I got you, Rolla. I got you.
Thank you. There's no real accounting. Now, I'm not saying that undermines the conclusions of ARCCA. There's another okay, so to speak, with ARCCA. Or I'm not saying they're not qualified witnesses, but it certainly shows some bias. I went over a lot less than blah, 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 blah. Now, here's the next one.
Yeah.
Another comment. He's quoting, would it be fair to say, because you had a lot of nighttime visibility work, your cases frequently involve pedestrians? Now, and then yes, unfortunately, there is a direct correlation between the time of day and pedestrian facilities. Statistically speaking, most pedestrian facilities occur during the evening.
Fatalities.
I'm
Oh
sorry.
my God. I hope he brings up the because remember I pointed out when we watched the hearing last week, I was like, oh my God. So some people were really freaking out about that. And I was like, I don't know what's going on. Do they not realize? So Brennan kind of made it seem like he was reading the email verbatim. And so people must have thought that was in the email, and I was like, no. He added that. That was him adding that. Shh, don't tell anyone about it or whatever. That was Brennan. I wonder we're about to get there. I wonder what happens. Oh boy.
Thank you. Fatalities occurred during the evening and night hours. End of quote. And then the Commonwealth adds a commentary. That would have been nice to have.
Mhm.
They had it. They had that. What's the objective evidence that they had it?
Yeah, that's not the part I was thinking of.
I go back to the one. They had it 4 months ago. 4 months before last Tuesday. They had it
Actually,
before we turned over the discovery.
I think it's coming right
What's
up.
the objective evidence that they had it? Is the voir dire of June 18, 2024.
Yep.
Of Dr. Wolfe that I referred to earlier, page 167, line 12. This is Dr. Wolfe. Well, to give you an example of that, so I do a lot of nighttime visibility work, where, for instance, let's say pedestrians coming down to the roadway, et cetera, et cetera. But that's not the end of it. They had it twice. So if we go to the direct testimony of Dr. Wolfe that I referenced earlier, this is my text, but I'm going to stick with, it's the date of June 24, 2024 of Dr. Wolfe. Page 36-65.
Okay.
Line 22. This is Dr. Wolfe's answer. Several hundred, period. As I mentioned earlier, you know a great deal of my work is in the field of light and visibility. Here comes the key points. So there is a direct correlation between time of day and pedestrian incidents. We see a rise in the evening and night hours just due to drivers having a difficult ability to try to perceive and recognize individuals. So I certainly see a lot of pedestrian collisions in my casework. There it is.
I did see that.
So let's go back. That's misstatement number 5.
Wow.
It would have been nice to have. I agree. It would have been, and you did. Twice.
Awesome. Get him.
Reading on the same page 16.
Oh my God. He's about to get to that part where I guarantee you, roast him for that. The way Brennan did that shh, and people thought, dude, oh my God. Yeah, he came straight into the team and is like the representative. Yeah. And the thing, he really has been doing a lot of the heavy lifting. And especially here, again, it was a really smart choice because of the fact that, you know, all this stuff that was brought up by Brennan had to do with the last trial and Yannetti and Jackson, mostly Jackson. But having Alessi come in, this was the right way to handle that. So
He's quoted. So, my specialty in the area of lighting and human factors results in a lot of my cases involving pedestrians. That's the end of the quote. And then the Commonwealth takes it on with the commentary. Pretty important stuff in this case. I agree. And you had it twice. And then he comments, if you don't want me to say this, that's fine. That's fine. Then the commentary from the Commonwealth.
here we go.
Shh. And I went back and watched the video. Shh. Don't tell them. I'm sorry? What do you mean don't tell them?
Yes.
You were told twice. In the voir dire, and in the direct, it was just unvarnished. And here's the important part, Your Honor, another important part. Mr. Jackson drew that out on direct. Not only was he not shushing or hiding, it was Mr. Jackson's question that drew that out. So here you have Dr. Wolfe trying to figure out is this something that we should say or not. And honorably, Mr. Jackson, no, we're going to hit it head on. Mr. Jackson draws it out, puts it right on the table. 4 months before February 18th in the whole Wolfe live.
Yep.
Next, if you could, Your Honor, please go to page 16. I'm sorry, there's another point. No, let's go if we could. I don't want to take the lesser significant ones. I want to focus, because there's many of them. I want to get to the more significant ones. So then we have on page 60, line 2. And then a bill from ARCCA to the defense for $23,925.
Okay, the bill.
That's not a trial by ambush. That's getting duped. So I, Attorney Brennan, didn't know any of this. But I tried a few cases. I've been around federal court a bit. I know how it works. So what is the import of that statement? I didn't know any of this until I got from the federal government.
Here we go.
And we're talking about the invoice. No, you know about it because the defense, after the certificate of completion of discovery, in 6 weeks before the trial is starting, the defense affirmatively turns it over and does it not buried among several discovery documents, but essentially a tailored discovery response that's titled Karen Reed ARCCA Reciprocal Discovery. That's not a very good way to try to cover up something. There is no statement about the date of the invoice on February 18th. So people are left to wonder, when did it occur?
This is what I was saying. I was like, oh my God, don't even tell me there was a date on this invoice. Don't even tell me. Because he gave a date earlier. However, I thought, okay, well, maybe it was like he went back and saw the date and then that's how he got it. But if there was a date on it and Judge Bev said, when was this dated? And he's like, it doesn't have a date. And there was a date on it, I will lose my mind. I'll lose my mind.
When was this bill stated? The date's important for that invoice.
Oh my God.
Then there's a lot of statements made, sometimes parties pick sides, agree, blah, 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 blah. And then it allows the ability of one side to use ghosts. They create illusions and shields and say something's there and something's happening, a federal investigation, and this person, and then this happens.
Yeah.
Your Honor, I think it's important for the defense to be allowed to speak to the very words that were used against us.
Please.
Ghosts, illusions, shields. That's what we're accused of.
Yeah.
I choose.
That bothered me too, because I'm like, why is he, if he really had something there, why would he say that and then switch to ghosts, shields, and nonsense that doesn't mean anything, right? It was weird. It was like, why would you not just like drop the receipts on all this? And now instead you're switching to this type of thing. I mean, I'm glad he's highlighting this.
To try to comport myself and practice a certain way and give people a little bit of the benefit of the doubt. But if we're going to be talking about ghosts, illusions, and shields, I don't think it's the defense that's creating ghosts, illusions, and shields here. The illusion, and it's more than illusion, it's a statement of fact, is that all these documents came from the federal government. It's not an illusion, it's a statement of fact. Statement about federal investigations that were these are not ghosts, we're not creating it, but I'm not gonna go any further on that topic. But the ghost word was used, in my view, the way I read it was, these topics we're making up, right? And we're hiding things, shield, right? We're shield, I interpret it, you're preventing us from getting this information defense. And this is fine.
I just have to, because it's losing my mind. Do 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 do. Ooh, you know the song. Where is my mind? Where? Who does that? Why am I blanking on that? Oh, the Pixies. Duh. Yeah. Where is my mind? Okay. Anyway.
We have provided. Next line. Page 60, line 13. I don't care if the ARCCA witnesses testify at trial. I'm very pleased to hear that. I don't care about their opinions. I'm pleased to hear that too. But I care that it's unfair, imbalanced, and hidden. Hidden. And that is based upon the faulty premise that we didn't turn it over and the Commonwealth got it from the government. There's no other way to read it. And the Commonwealth, like the defense, is entitled to discovery. I agree with that. The Commonwealth is entitled to discovery, and you got it 5.
Last week when we were watching this, I paused it after Mr. Brennan said the Commonwealth is entitled. I paused it. I said, I agree. The Commonwealth is entitled, you know, as in like entitled, stuck up, you know what I mean? Like, it's really funny. And he's saying, I agree, the Commonwealth is entitled, but then he's adding on to discovery. But it's just funny because like the first part of that is exactly what I said, but I meant it in the other way.
5 days before February 18th. Now it comes to the court. All right, I'm going to take a recess. And I certainly, Your Honor, am not going to be so officious as to even delve into why Your Honor wanted to take a recess. But I will tell you what I thought and what I believe occurred. Your Honor listened to a completely counterfactual rendition of some of the most important issues of the day and frankly of the moment in this trial. And the reason I got a little bit of an inkling is because what happened when the court came back. So what I concluded, after all of this, the court saying the break is, you know, after all of these inaccuracies and piling on of inaccuracy after inaccuracy, there's a cause and effect in my mind between the several and serial inaccuracies, the break right in the middle, and then the court comes back. And I understand, I don't really, and I'm going to get to this, see the justice in terms of this presentation to the facts. And that's what we're going to be talking about, facts and representation. So here's what the court says. After hearing all of this, and I want to underscore something, Your Honor, and I'm not going to get too lofty with due process and notice, but it's important to hit some of these points. All of these topics that were raised were not in a motion. They were not in an affidavit. And I've had this issue before with other motions under what's required in an affidavit.
In this case?
No,
I'm saying generally, you've had this issue in other cases, or do you mean?
Other cases, Your Honor. With there not being an affidavit, right, where someone's got to be very, very careful about what they say. But in this information that Your Honor had to be subjected to was not in anything that we had notice of, these topics. We had no notice that this was coming. There was no affidavit that someone had to swear to that all of these facts were correct. And Your Honor takes the break. So we didn't get an opportunity to stand up and say, you know, being given the very fulsome opportunity to say today. So Your Honor comes back. All right.
Well, that makes it clear they would have wanted to talk. Of course they would have. I mean, we all know that. Wow. So, and I will say that my interpretation of last week was that this was sprung on them because it was kind of like at the end of his whole thing. Like he was going on about the other discovery motions, and then this was just like a whole other thing, right? And it was like, what? You know, and I got that impression. And maybe he did that on purpose so that he would hope that maybe they wouldn't have time to respond that day. I don't know. I don't think there's any way he could have known that Judge Bev would have just ended the day early, but wow. Wow. Yeah. Last week was crazy. And the thing about that was, right. So it's because a lot of the same law enforcement officers were involved with that case, that worked on that case, not actually her dying. The cop that was responsible for her dying is in federal custody waiting trial. But they covered it up is what it was. And they were also the cops that worked on Karen Reed's case. So who doesn't know what yet?
So the Commonwealth just provided the court with information. And I don't even want to repeat these words because it almost pounds onto the prejudice to the defendant. But Your Honor well knows what Your Honor said. But it certainly had the words in there that were very, very difficult on the defense. And you say, so for that reason, right? So the Commonwealth just provided the court with information that causes the, and then it goes on. So it's clear that Your Honor was relying upon that information, which was only given verbally, right? And you say, so for that reason, I'm going to suspend today so that we meet again, and then the rest will be back in here. Unfortunately, that's not the end of the prejudice. So what happens is, all of a sudden, and Your Honor basically said, and this is all so key. So you said, I'll see you in a week from today, and then Your Honor continued on page 61, line 12. And Mr. Brennan, where the federal authorities have been kind enough in the past to allow me to have copies of everything, would you be kind enough to call over there and check with whomever you were dealing with, so to see if I can, in fact, get a copy of everything that you just read? It was only then, when the specter, the reality hits, that you're looking for the backup.
Oh, I didn't catch that. And I don't know that anyone else caught that either. Everyone seems to think that over the break, Brennan changed his mind and decided to and that's what I thought. That is interesting. It was only because Judge Bev asked to see the discovery that he fessed up. Oh, well, then it was intentional. There's no way around that. Holy fuck. Really? That blows my mind. I can't wait to see what other people on Law 2 think, because literally, again, the people that were like, it couldn't have been intentional, even though the signs were pointing that, was like, no, because it would be too stupid. It's like people were like, did he want to lose his law license? Like, what are you doing? This is such a big deal. Oh my God. Wow. Wow. That's a problem. That's a problem for Brennan.
What's being said. Up to this point, Your Honor's understanding, all of this came from the feds, and the defendant didn't turn it over. So what does the Commonwealth do now? Does the Commonwealth stand up and say, whoa, wait a minute, I made a mistake. And Lord knows I've made mistakes before. They didn't stand up and say,
right,
a very significant mistake.
This is what I said. Remember when I was like, he could have fucking groveled. He should have come back and right off the bat and done it in a way that completely made it clear he made a mistake. And he didn't do that. He tried to bury it still, right? By saying, I'm just going to go over a timeline of the document or whatever. And I was like, oh, fuck. I was just commenting on this earlier, and this is exactly what he's pointing out. Maybe he was hoping that Judge Bev still wouldn't catch it. Maybe? Wow.
Predicate for my whole presentation was, I had to even fight the feds to get this information. Lo and behold, I got it, and I've been duped, and I've been ambushed. Rather than saying that, you know what, I don't even know if I would have had the courage to say in open court. I might have asked for a sidebar and come up and said, Your Honor, my bad. This is that. But that didn't happen. Nope. So what did happen? The Commonwealth says I can, and there's a brief chronology I think Your Honor should be aware of. So the defense is still not able to get up, but the Commonwealth is continuing on. If I could add that right now, it will take me less than a minute. The court, okay.
There you go.
So the Commonwealth goes on, says the chronology is December 4th. We sent another 2-week reply in 2024. January 6th, we filed our notice of intention to exclude ARCCA experts. January 30th, 2025, the United States Attorney's Office sent a response to both ours and the defense request. Without any prompting, on February 6, 2025, the defense and the prosecution received an email from the U.S. Attorney's Office saying that the contract had ended with the ARCCA experts and that if either party wanted to engage, the original materials are still protected. This was a change in position about whether the party could be impeached. On February 11, we filed a motion to exclude. February 13, the defense provided us the emails that I read. Buried in a chronology is, and in the middle of the sentences, the defense provided us with the emails. I think I said, I'm going to repeat that. I think I said, the federal government, it was the defense. February 13th, they sent us the emails in the direct examination outline. I think I said, that was the whole basis for the entire presentation, was that the Commonwealth had to fight even the feds to get that. And then it goes on. We reached out to the federal government, but you know what was not said in lines 9 through 14? What was not corrected? It wasn't corrected that the invoice came from the defense. Just emails.
I thought it meant everything, but
I don't understand.
And I literally pointed that out last week. That's crazy. I literally pointed that out last week. I pointed that out. I said, here's what he corrected. He corrected the emails. We didn't say the invoice. We talked about this, and I was like, what does that mean? Does it mean, because we were trying to figure out if the invoice maybe had been sent to the feds. Oh, man.
And how that conclusion can be drawn, Your Honor. It didn't say the defense provided us with all of the entire production. The defense provided us the emails that I read. There was no email with the invoice. The invoice was discussed as a separate item, and I can go back to it. When the Commonwealth was talking about it, they never connected it to the
We
emails.
literally did this because we were like, hang on, is this include? Wow.
So then we reached out to the
because I
president.
I received a copy of it.
Pardon me?
I think it's because I received a copy of everything that had been referenced.
Yes, but I'm going to get to the point about the importance of correcting mistakes, because 3.3A1, everybody focuses on the first sentence, which is, thou shalt not make a false statement of fact to a court. The second part of 3.3A1 is you get the opportunity to correct, and you got to correct a material. And I've got it in front of me, but I'm just paraphrasing. I want to get it precisely. But that's why I separate this on this, Your Honor, because I trust that the court's going to hold everybody to the same standard. And so I think there is a proper equal.
The thing is this, right? Remember how pissed she got last week when it was represented to her about these issues with candor to the court, right? A false statement, like he was just citing the ABA model rule, right? And how upset she got. And now, when he's showing, in fact, it was the other way around. It was Brennan who was misrepresenting and misleading the court, right? And what does Judge Bev do? She doesn't sound mad at all, but not only that, she's like, oh, I thought it meant everything. Bullshit. When the point about the emails and the invoice, bullshit. Because we asked that same question for slightly different reasons, because we were trying to figure out maybe again that potentially the invoice had been sent to the feds, because Brennan didn't give any information about when it was dated from, like who it was to, who it was from, when it was dated. It was just, this is a bill. And it's like, well, that doesn't mean it was paid, right? And so we were going through all that. And so I know exactly what he's talking about. And here's the thing. The way that it was parsed out by Brennan, and then the way he said the emails, but not all the discovery, and he didn't say emails and other discovery. He didn't say emails and the bill. He just said emails. I don't believe her that she said she thought it meant the bill too. I think she's saying that to try to defend the Commonwealth. And it's disgusting because we all saw what happened to her last week. And I will say this, to the extent that Judge Bev is who she is, when you have problems with candor to the court and all that, right? What we're talking about here are these ABA model rules violations. That doesn't matter, thankfully. In other words, any sanctions that should happen in terms of this criminal case to Mr. Brennan are going to be up to Judge Bev, and they probably won't happen, unfortunately. However, when you've got these violations of the ABA model rules, that is separate. That's a completely separate board, has nothing to do with Judge Bev. And what happens is when you're an attorney, when another attorney breaks one of those rules, it is your duty to report them to the bar. And in fact, if you don't, you yourself then are at fault. So in other words, Judge Bev has nothing to do with it. Again, it would be great if it had the proper effect. And again, I don't know what's going to happen. I would imagine though that Judge Bev is going to protect the Commonwealth in direct contradiction to how she treated the defense last week. However, regardless of that, in terms of the other the real major repercussions for Brennan would be as it pertains to his standing with the bar, and that will still happen regardless. And they will report him to the bar, and they will send this over. And the bar is completely separate, and they will probably end up having a hearing over it. And this is how attorneys can end up in huge trouble. They can be suspended, or they can lose their license entirely. So there you go.
I don't intend to be officious as to what the court should do, but if we're going to start looking at comments of defense counsel, I believe we have to look at all comments. And again, I'm going to go back to my own view is this: being a lawyer in cases like this is hard. Being a judge in cases like this is hard. Mistakes are going to be made. So we go on into page 62, line 50. We reached out to the federal government again because I was curious about the change in position on February 6th that the contract was ended, but that parties could contact ARCCA. Obviously, the Commonwealth is in no position to contact ARCCA because that would naturally preclude the defense from retaining them. So we refrained and we will not reach out to them. This is really an interesting statement because you read it because that would naturally preclude the defense from retaining them. Yet at the same time, the Commonwealth, for the fourth time, has moved to strike our ability to use ARCCA. So then the court goes on, all right, so the information that was provided to you, not from the federal government, so Your Honor knew at that point, I don't believe Your Honor had any basis before that to believe that it had come from the defense. I'd like a copy of it before you leave the courthouse. So I harken back, Your Honor, to what I conclude drove Your Honor to make those impactful statements about, on the top of page 61 was the presentation of the Commonwealth that I counted had 10 misstatements, 10, before Your Honor caused the pause. So,
oh boy, 10 misstatements.
Coming to what happened then. The Commonwealth having not given us notice that this was coming, these topics, not putting any of these statements in an affidavit, we didn't have the ability to stand up. But I will tell you this, Your Honor, I greatly appreciated the week that we got.
Okay.
Because I do believe that Your Honor intended that counsel be given, defense counsel and defense a fair opportunity to go look at this. And that's the way I'll speak for myself.
So he's giving her the benefit of the doubt as well, that she really was giving them time to prepare and wasn't trying to cut them off without being able to say anything.
That's the way I took it, and I appreciate that, because that's allowed me to go spend the time that I spent to try to do my level best to give the court an accurate rendition of the fact, because as an officer of the court, I believe that is a sacrosanct duty. And in a matter where the very issue is where counsel saying to the court it isn't accurate, I wanted to make sure I could do the best I can. Now, I may have made a mistake here or there, but I just wanted today, but I want to make sure that I recognize Your Honor's giving us that week, and we try to take the best opportunity for it. So what happens? What happens after these 10 misdirections? The court's comments go viral. And I'm not saying this for drama's sake. I'm saying this for what
Are you saying directions? So he's been counting some of them out loud, but there's some that he said he's skipping over because he's saving it for he wanted to only go over the biggest ones because Judge Bev is always like, time. But I guarantee you they're all labeled in his binder with his tabs. Maybe each tab is like another misdirection. Who knows? But I'm sure he's got it well organized.
After the defense 6 weeks before trial starts, while jury notices are out in the mail. Those words, based upon the misdirections that your court had to endure, have gone through, and I'll just name a few headlines in the Globe, the Herald, every TV outlet, social media exploded. And these are not trivial issues. And more than that, the veracity of counsel has been called into question. There's commentary of everybody about what's going to happen to certain members of the counsel's team, and whether it's intended or collateral damage. We've got the ARCCA experts, which are key parts of our case. Their credibility is being pillared throughout the public domain.
So what he's getting to now is what a lot of people thought, including myself, that Judge Bev was doing, which is that now it gives everybody a week to be like, oh my God, the defense did something shady. The ARCCA dudes, again, that was it, right? To try to have them be smirched, because now it's like, right? And so he's speaking to now the damage that was done due to the fact that they weren't given a chance to respond.
This could have been avoided had there been an accurate recitation of what had occurred. And Your Honor, I don't know if this can be remedied.
Oh boy.
But it surely shouldn't have been exacerbated.
Yep.
I would now like to move rather hopefully efficiently through the next step, which is to point to the Massachusetts rule and give the court my view. And I have to reference what Your Honor brought up.
Okay, you don't have to tell me what you're going to do, Mr. Alessi.
Sorry, I'll just go ahead and do it. My apologies. So now let's just turn to
Please pull it up. I hope he's going to the ethics rule. So whenever he talks the Massachusetts model rule of ethics, it's going to be very similar. It's going to have everything that the ABA, the American Bar Association, has. There might be some additional things, but these are all very similar. Please, I hope that's what he's going to. I want to see Brennan pay for this personally.
Model Rule 3.3A1. And this applies to every counsel in this room, of course. A lawyer shall not knowingly, so there's the adverb of the mens rea, knowingly, make a false statement of fact or law to a tribunal, or fail to correct a false statement of material fact or law previously made to the tribunal by the lawyer. So we all know the mens rea of knowingly. This court knows it better than everybody, so I don't have to get into that. But in terms of making a false statement of fact or law to a tribunal,
here it is.
I don't see that on behalf of the defense, and I'm going to get to the new item of February 6th, because we haven't covered that. Your Honor brought that up today. But certainly with regard to the representations that I've gone through, the statements that were made, especially on June 10th, they were 100% true, inaccurate at that time. They were 100% true, inaccurate, and that's why I went through the note. Or fail to correct a false statement of material fact or law previously made to the
I
tribunal.
love surveys too. I take a survey any chance I get. I freaking love surveys. In fact, there's like some different like apps you can have. Like I have one on my phone where you can like just like take surveys and like they give you points and the points turn into money and it's pretty fun. Anyway, and the surveys are all kinds of different things. It's just like one of those fun things you can do if you're just like waiting in line for something or whatever, and take a fun survey and then they give you extra points and like it kind of adds up after a little bit. I don't know about that. Yeah. So But yeah, so here, if it's a false statements made to the tribunal, it's a problem.
By the lawyer. And there's no real time period that's given for the attorney. But here is something very important, Your Honor, and I'm going to parse the grammar because it's what you do in construing the statute. It says, or fail to correct a false statement of material fact or law previously made to the tribunal by the lawyer. So the is a definite article. So it's like an adjective, it's a definite article. Lawyer is the noun. The lawyer refers to the lawyer who is perhaps made a false statement of fact or law to a tribunal. So it's sort of like, you make a mistake and it happens, but you got to correct it, right?
Yep.
And what they talk about is what do you have to correct? You have to correct a false statement, so it has to be false. It has to be knowingly false.
It's like the element.
Of material fact or law.
Material fact or
And
law.
material has been interpreted in the context of 3.3A1.
So this matters. He's going through the, you know how we go through elements of a charge for a crime? He's going through the elements. It says the law is so funny, right? So in other words, for the ABA, the rules of, it's the same thing. There's elements for each thing. So cute, right? So he went through the elements there. It has to be a lawyer. They have to make a false statement. They have to correct it, right? And then, but it has to be material, right? And so it can't, so in other words, if you just like get something wrong, but it wasn't a big deal, right? So he's right now about to give the interpretation of when is something considered material. So he's going to, right now, what he's proving is he's proving how Brennan violated this important ethical rule from the bar.
To be a statement of fact or law that caused a court or adjudicator to have relied upon it for a determination. It's essentially what the case law talks about. It has influenced the judge's decision. Mm-hmm. So let's go back and even let's assume hypothetically that on June 10th, there were misstatements made. It's not any misstatement. It has to be a failure to correct a material. You have to do it knowingly, and then you have to fail to correct a false statement of material fact. And in terms of what Your Honor had, it's the same lawyer that we're talking about in both clauses. And that is why I spoke about Mr. Yanetti's statements on the 10th, about what he knew, the fact that Mr. Jackson was handling the ARCCA experts. So it's important to be analyzing what lawyer is saying what and which lawyer is to be making correct to correct the statements. So I go to the analysis with regard to 3.3A1. As I said, I'm keeping separate 3.3A1 from Rule 14 because they're different analyses as the court knows. But I want to hit the one of the most important ones first. So there's not a false statement of fact or law to the tribunal, and I will stand here as long as Your Honor needs if Your Honor feels differently based upon what I've said. Or fail to correct a false statement of material fact. So what I'd like to do, Your Honor, is now go to what Your Honor brought up today, because I was prepared for the June 10th.
Okay, so I think actually, maybe he's going to do two analyses. I thought the analysis he was doing was going to be then proving how Brennan, but instead what he's doing is he's showing how they didn't violate anything, because it was kind of implied last week, right, or inferred due to Judge Bev's reaction and all that, right? It was like nothing was said about like, okay, violating the rules of ethics or that, anything with the bar. But it was, everyone understood that was what was being implied. And so he's now going through how they did not do that. Brennan's the, well, I do. So Brennan's for the Commonwealth, right? Brennan's the one who we heard talking last week. He was the only one. Well, early in the hearing, we heard from other defense attorneys, but the one who made all those accusations and allegations against the defense, Brennan's the special prosecutor who was brought in. He's normally a defense attorney, right? Brought in as a special prosecutor for the Commonwealth, and took over. And now Ollie just sits there like furniture. So we have not heard from Brennan yet today. Personally, we've heard his statements read by this. This is Mr. Alessi. So yeah, he's not the new DA. He's just a special prosecutor. DAs are elected. The DA is Morrissey. Morrissey is still the DA, extremely corrupt. There's problems. There's all kinds of problems there. But the DA is Morrissey, but Brennan is the special prosecutor. So it's just like in what happened with oh my God, why am I blanking on his name? Dude, Alec Baldwin. Ironically, another Morrissey. In that case, Kerry Morrissey was brought in as a special prosecutor. So they bring these people in, they're usually defense attorneys, right? They bring them in literally just to help prosecute one case, and that's all they do. And then they go back to whatever they were doing before. So In fact, Brennan, initially, when he came on to this case, the first couple hearings, he kept accidentally referring to his opponent, as in the other party, as the Commonwealth, because he's so used to being on the defense. And then it took him a while to adjust to the, wait, I am the Commonwealth, sorry, pretty funny. Yeah, you're right. He does look like that, doesn't he? From the
Do you need time?
I don't. I've taken the time. I appreciate the offer. But I would like to draw your attention, Your Honor, because like I provided context on June 10th, I think context for February 6th is important. And so what I'd like to do is to go back earlier than what Your Honor quoted this morning, because I think the context is important.
All right, so I have that entire transcript, like I said.
Thank you.
Paging rep.
I am starting on page 4.
Brennan, another thing, Brennan has the real nasally voice.
Okay.
It's so funny
I
because
started with line
new
1.
faces, both sides.
Mr. Brennan, correct. I had a conversation with one of the 2 prosecutors I spoke to, and the only means of trying to obtain information they suggested was through a TUI request. I don't think it's the Commonwealth's obligation to seek discovery, part of Rule 14, but I wanted to assist the best I could, so I made an assented to request, and they responded with a letter. I think you received a copy of it. Do you mind if I share it? No, okay, I received it. I sent a TUI response, essentially rejecting all of my requests on multiple grounds. So to be fair to the Commonwealth, Your Honor, this is February 6th, and they haven't gotten our discovery, right? They're just still trying to get it from the government. They don't have it from us yet. The court, all right, can I get a copy of this? If not, I just need, and then Ms. McGuffin, you can retain that copy. Thank you. So I'm not going to stay here and read it right now, but all right, Mr. Brennan, of course. And so inevitably, I'm not making any motion right now, but I appreciate that as a proponent of the evidence, defense's obligation to give Rule 14 discovery. I do not think, even despite the testimony, they complied with Rule 14. And so the reason I forecast this was because I appreciate the April 1st trial date. If the defense, through no fault of their own, is unable to comply with discovery, I think that we're entitled under Rule 14. I would at that point move to preclude the risks. So I think the important in this snapshot of time is all of the discussion that occurred on February 18th, and I'm going to underscore this. That presentation was not about the substance of what was in the email. The Commonwealth never had an issue with that. It was all about they had to get it from the federal government, and we didn't turn it over. Your Honor, obviously, read the February 18th transcript. You can draw your own conclusion. But on February 18th, they were not on the issue of anything other than.
I remember I just said so funny. All the things I'm saying. So I said this just a few minutes ago, how Brennan tacked that on at the end. They were there to discuss the Rule 14 discovery motions, and that he's just highlighting that, right?
They thought that they didn't get the material from us. So now we continue on. The court move to exclude the witnesses. Mr. Brennan, yes. The court. What do you say, Mr. Jackson? Mr. Jackson, I don't want the witnesses excluded. What do you want me to say? The court. I asked you all to try and work out something. The original protective order permitted that we can do in court anything that would rule. I expect you to say something a little more than that because, and Mr. Jackson, well, I'll wait to get this motion. Court, all right. Last time, Mr. Jackson, let me put it this way. The court, hold on a second. Last time we did voir dire these witnesses, it seemed to me that was the logical conclusion. I'd be able to get both sides discovered. We did that. That seems like a logical alternative to the exclusion, right? Your Honor knows what you're doing here. I guess we can wait and see if I exclude it on a motion to exclude. It just makes sense to me to set that up now rather than wait. I don't know when they do that, when the Commonwealth, based on their witness list, recalls them is that when you want to exclude it. So I sort of expected the defense would have some suggestion. If you don't, you don't. Mr. Jackson, this is the key context. I can tell you this, the Commonwealth has exactly, this is an interesting and sort of different set of witnesses. The Commonwealth is saying that pursuant to Rule 14 and, exclusion and preclusion of a witness is a punitive sanction for Rule 14 violation. Ms. Reed has not violated anything. Why should she be penalized when the Commonwealth has the exact same batch of information that we have about these witnesses? And there's more context to that. I understand the import of these words so far. So I don't have any more information. I don't have any additional discovery. I didn't hire them. I didn't ask them to engage in additional protocols. So I've got nothing else to give to Mr. Brennan. He's got the same information I got and he got at the same time. What Mr. Jackson is referring to here is the disclosures from the U.S. government, not the disclosures that were going to occur on February 12th and 13th when we would get the certificate. We had the certificate of completion of discovery. We had 30 days technically to turn it over, but it got turned over on the 12th. So then it continues on, is important. The court, if I don't exclude it with other sides seeking a voir dire, we would not seek a voir dire because they're eminently qualified and there's no other discovery to give. They provide. The federal authorities provided all the discovery that was intended to their analysis and testimony. So what we have in terms, Your Honor, this is important. I'm going to go right back to 3.38. We have Ms. Little handling all the discovery. Mr. Jackson is not sorting through discovery, knowing what we got, not recalling what is in the possession from March 22nd, not recalling all of those items. That was Ms. Little's responsibility. So what happens? What happens is Ms. Little handles the production, goes back and does the diligence that she always does, takes all that material, sends it over to the Commonwealth.
So they had just really delegated
February 18th,
assignments.
the defense did not have the opportunity to address the issues that Mr. Brennan had brought up. But I now want to go to the statute and why it is important. Because the whole issue of discovery, the whole issue of batches of information was provided. And it was provided before, well before the 18, before any of these issues came up. And Your Honor, respectfully, whatever the court may consider to have been an inaccurate statement, there is no knowing misstatement of fact. Mr. Jackson has never, I can tell you this from personal experience, I don't see him ever touch one item of discovery in terms of here's what we're going to collect, here's what we're going to turn over. Never have I seen it happen. I've spoken with him, he can speak for himself. That's not, so there's, even if you take any read of February 6th, Mr. Jackson is focusing on and thinking that discovery is just what everybody has from the federal government. You've heard this many times. We can't produce more than the feds have, but we certainly, and I want to hit this head on, we certainly had those March 22nd, March 22nd, we had those emails at the time that statement was made. We had those. We had the direct, we had the clause, not running away from that. But the question is, at the time Mr. Jackson made those statements, he's focusing on the government, and he's not knowingly saying in his mind, oh, well, I know we've got these emails from way back when. And so with regard to the shall not knowingly, there's no evidence of knowingly here, and I don't believe, respectfully, there can be an inference stated. When I looked at every...
And he's addressing the elements of the model rule there, that if something has to be done knowingly, right? We see this again. This has come up a lot with Franks and stuff, right? For the law enforcement officers knowingly, right? Making a false statement. Similar thing here. He's addressing that it was not done knowingly.
Every single case where the court can look at the circumstances. So knowingly is not merely a subjective question of what an attorney has. The court is entitled to look at the circumstances, and the case law says should make an objective determination on knowingly. But the cases, and I can give them to Your Honor, the cases are legion, that the court cannot draw an inference from no fact to conclude it was knowing. They got to have some basis, and I'll give you some examples. What happens is if, let's say somebody, one of the leading cases is, unfortunately, a woman attorney was in a bad divorce, she had financial statements, and she made misstatements of fact about financial statements. And then the question came, did she knowingly know? And what the court did, she said, no, I didn't know it, I didn't remember it, I was under psychological stress. And what the court did was they went and they looked at the circumstances and saw emails and conversations she had with her accountant, where she clearly knew about those statements, and she told the court she did. So there's an example of you've got to have circumstances that the court cannot just jump from a lawyer said this to it's knowingly without some basis. That's why the mens rea is there. So in turn, and that's the February 6th, respectfully, that's the only aspect of, and I went through all the others, that even comes close to a false statement of fact by Mr. Yannetti or Mr. Jackson. In some, Mr. Yannetti's statements on June 10th, all completely accurate,
I love that we have Frank.
Mr. Jackson's eliciting of the direct testimony at trial.
No, it's Frank.
He asked, if I ever asked you specific, questions, etc. That's completely true because it was Dr. Wolfe who sent the questions in. So we now are left with February 6th, and I've given you that construction of the statute. My last point, Your Honor, is going to go to the Rule 14, which is, and I'm going to spend a very short amount of time on this.
Okay, so he's almost done.
You
know what that means? We're going to hear from Brennan up in just a minute. And what is he going to say for himself?
Now that the Commonwealth knows that the discovery came from the defense, I want to go back to, please, the February 18th transcript, because I want to keep separate analytically the ARCCA from defense counsel. Because obviously for Ms. Reed is obviously very concerned about her defense counsel and her choice of counsel, which is going to be my last legal point. But in terms of what occurred, I want to go to and quote the Commonwealth on the transcript. I am on page 62, line 18.
Again, what he just said there,
and by the way,
what he just said there about how Ms. Reed is very concerned about her choice of counsel. Again, that's addressing the things that we were just saying, right? Like potential outcomes of this. Could Alan be kicked off the case? That would be a really harsh sanction. That would really punish Miss Reed. I'm saying Miss Reed because he said it. We punish Karen Reed a lot, right? And so, but anyway, so he was addressing that, and now he's going to the ARCCA dudes, right? Because another option, if she was going to punish the defense, which it's clear that there wasn't really, again, there was maybe a slight discovery violation here, but nothing done with that would violate the model rules, the ABA. So, the thought of removing the ARCCA dudes, right? So it'll be interesting to see what else he suggests if is something for the discovery violation. We'll see what he says.
toward the very end of the 18th. Obviously, the Commonwealth is in no position to contact, et cetera, and what does that relate to? If Your Honor would go back to page 60, line 13. And it's a repeat, but I didn't get to the point here. I don't care if the ARCCA witnesses testify at trial. I don't care about their opinions. But I care that it's unfair and balanced and the Commonwealth, like the defense, is entitled to discovery. Key line. So if they can produce the discovery, I welcome ARCCA. I want to repeat that.
You don't need to.
I'm sorry. Okay. So my point is, we produced the discovery. Why is there still an issue with ARCCA? These aren't my words. So I want to cover, before I get to the Sixth Amendment issues, the point that ARCCA should be allowed to testify. We've complied with our Rule 14 obligations. There's no prejudice. They have the discovery. They've obviously had from the government a long time everything about ARCCA. So I want to touch that base to make sure that either intended or collateral damage that ARCCA still gets to testify, because it's a key part of the defense here. Now to the Sixth Amendment. The United States Supreme Court has held repeatedly that a defendant's Sixth Amendment right to defense counsel of their choice is a root basis of the Sixth Amendment. Is it an absolute right? No, Your Honor. If counsel does something so egregious, does it correct it? The Sixth Amendment gives way to the need for the court to have candor, the need for the court to have decorum in the courtroom. So I understand that. My presentation today was as an advocate, of course, foremost, but also to provide all the information. So when Your Honor balances that sacrosanct Sixth Amendment right with whether or not there has been such a level of conduct that can be diluted or trumped. And I give Your Honor United States versus Gonzalez-Lopez, 548 U.S. 140, 2006. And in that case, there was violations of the local rule. And the court, and the court struck their counsel for that. And the
Is
U.S.
that
Supreme
counsel pro hoc vice, or is that not?
I'm going to get to that. The answer is the counsel. I want to be sure of my answer. Yes. And I'm going to read my conclusion because it doesn't say pro hoc vice, but I'm going to read you a part of it. It says, during the hearing, however, the magistrate judge revoked Lowe's, that's the attorney, provisional acceptance. So I believe that's the parlance of pro hoc vice, Your Honor. I'm pretty sure, but I'm not 100% sure. And then
that matters because Alan Jackson is there pro hoc vice.
Week, et cetera, and then the revocation occurred.
Now, the other thing too, remember, there's still and no one thought it was going to ever get denied, but there was still the, motion to add Mark Better on pro hoc vice, and then Bev needed like an affidavit or some other clarifying information. So pro hoc vice could pertain to Mark Better or Alan Jackson. However, I don't think it would make sense to punish Karen Reed by saying, hey, like, don't let Mark Better on. Like, it seems like if you're going to, don't think you should do it anyway, but if you're going to remove one of the attorneys, it seems like you would remove the one who was involved in this particular matter, although who knows what Director Bev's going to do.
And
right, like it should happen.
Yes, it was. So the Supreme Court holding, government conceded that Gonzalez's Sixth Amendment right was violated below, but the court denied pro hoc vice admission based on perceived violations of a local court rule.
All right, so pro hoc vice was not permitted in. It wasn't a revocation of pro hoc vice. There's a difference.
There is a difference.
Oh.
In this case. Okay. There was both. Good point, both. So Your Honor, and there are other cases when you have the Sixth Amendment, the fact that someone is pro hoc vice status is not the determining factor. The Sixth Amendment, in terms of legal dignity, is way up here, and then the pro hoc and the local rules are down here.
Mm-hmm.
It's only when the violations that undergird the pro hoc vice get repetitive, get more than repetitive, but go to things that are done that aren't corrected. And the issues that I've seen in my research, Your Honor, is that they have to be the violations have to drive so much to the core issues in the case. It's like suborning perjury, putting people on the stand when they know they're wrong, literally having objective evidence. The counsel had a document in their hands, almost literally at the same time they're telling the court they don't have it. It has to be that severity to trump the Sixth Amendment. And why is that, Your Honor? Because the court has alternative remedies for if they really think that is happening. And that is going to be my last point on the Sixth Amendment. The case law is replete with the trial court having to be careful that whatever they do, even if they believe there's a basis for some sanctions, that the court look to do them post-trial so that there is not for the trial the bleeding in of those issues into pretrial matters.
Yep.
And
post-trial sanctions. So that could be, and they could even be something like a fine or whatever, but In other words, it should not affect her Sixth Amendment right. I agree totally.
The case law, there's a mention of that all the time. It encourages the trial courts to make sure that they're very, very sensitive to that issue. I don't think the courts are being all that sensitive and empathetic to the lawyers, but I think what they're doing is appropriately trying to make sure the defendant
The defendant shouldn't be
gets a fair trial,
Right.
right? And the defendant is not adversely affected by whatever the counsel may or may not have done. But I want to be very careful and clear, Your Honor. I'm not saying that is sort of like mitigation. I'm saying, importantly, the time I spent that there was not these violations.
Right.
If any occurred, they were
Right.
corrected. And on Rule 14, there's no prejudice. And therefore, I conclude, Your Honor, and I would urge the court. What happened on February 18th, there were some misstatements and they weren't cured. I don't want this to turn into, and I'm not making this argument. I'm not making an equivalence argument. I'm not saying, okay, now let's turn to the Commonwealth. To the contrary, Your Honor, and I hope I provided a factual and legal basis. I don't want any of this to continue. I don't want scrutiny of the Commonwealth statements on February 18th unless there's going to be continued scrutiny of the defense counsel. And I don't say this to camouflage or shield.
Wow.
We've got a lot to do between now and April 1st. The last thing I'm sure the court wants or anybody wants is to have something happen where that date can't be met because of whatever actions come out of this. My hope is that we all understand we made mistakes. Mistakes have been made clearly by both parties. And I would urge that the parties, not talking about the court, the parties take a breath, a deep breath, and focus on the matters that are important, which is how can we prepare to make sure that the presentations to the jury are candid, truthful, and most importantly, effective so that jury can make the best decision. There's a lot at stake here. The issues are momentous, and that is the focus of the defense. And I, again, conclude, but I would ask that I have, if anything said, if Your Honor has any concerns, I would really appreciate hearing them so I can take them on. Mr. Jackson, Mr. Brunetti, any questions Your Honor has, I would greatly appreciate it. My presentation notwithstanding, if there's still concerns with the court, we will take them on as best we can and certainly can. Thank you.
So I wanted to say real quick, that's the high road. I was fully expecting for him to ask that the Commonwealth be punished. And instead he said the opposite, which is, this is a distraction from trial. Like, we're all above this. Let's just do better. Let's continue on so we can meet our April 1st date, which is quickly approaching. Brennan got really lucky because, I mean, while Brennan was appropriately roasted, as it were, by the way he pointed out all of the misstatements, that's very clear. He could have additionally made a big deal about that, and he didn't. Now we're going to hear from Brennan, I believe.
I appreciate that. Before I give the Commonwealth an opportunity to respond, I need 10 minutes.
Oh, okay. He's taking a quick break. He's taking a quick break. I wonder what she's doing back there. What is she doing back there? Dude, is she mad? And by mad, I mean probably mad because he's right and she wants to, like, screw the defense. I don't know. We'll see what happens. You're back.
You are unmuted.
All right, so before I get to the Commonwealth, Mr. Alessi, I am going to take you up on your offer to ask any questions, and I may have questions for both sides.
Oh, okay.
Actually, what I want to do, and you said I could ask questions of other counsel. So while memories are fresh, I just want to show the accuracy of what was just said. So I'm certainly not going to order counsel to answer my questions. You don't have to, but I am curious. So we're going to start with you, Mr. Unetti. As an officer of the court, is there anything that you dispute that you just heard from Mr. Alessi? What I'm particularly concerned about is what you knew or what you didn't know.
No, what he said was entirely.
People are going to be forgetting about the OnlyFans when we come out with the new violin videos, as per Twiz's idea. Just kidding.
Okay, Mr. Jackson, same questions.
No, and I would simply elucidate with regard to the February 6th sidebar comment. As I look back at I didn't remember making a comment one way or the other. I didn't remember that sidebar.
I did.
Well, I'm sure you looked at the transcript. I did as well.
No, I did long before.
Correct. The context of that, what was in my brain when I said we don't have anything else to give, which my review of the transcript was very clearly the federal batch of information, what we refer to as the federal dump. I did not have in my head at all emails, communications, things of that nature, the small.
Invoices, payment.
No, nothing. I was, because the context of what Mr. Brennan was talking about being frustrated about were his TUI requests concerning the federal batch of information. And that's when I was making the additional statement. We don't have anything that they don't have concerning federal information.
That makes sense.
We have the background information for the
That
experts.
is a really important clarification. And see, this was a sidebar, so we couldn't hear it, but there's a transcript, right? That's a really important clarification because that was the only other thing that was left hanging is like what was in Alan Jackson's mind when he made that statement, when he said we don't have anything else to give them. That's important information, that because what Mr. Brennan was complaining about was federal, right? From TUI. That makes perfect sense that was what he was responding to. Okay.
No, hold on.
You got it.
It was just thrown on you that you're excuse me, that you're responsible for all discovery. The same question to you, and again, you don't have to answer, but is there anything that you dispute in the accuracy of what Mr. Alessi told me about what you knew and what you didn't know and when?
No, Your Honor, I would just add that as soon as the court issued the order, obviously it was not in court that day, but as soon as the court issued the order that ARCCA reciprocal discovery be provided, I gathered those documents and I provided it. So that was the, I guess, prompt for going to look to see if we could satisfy the 10 things that were outlined by Mr. Brennan.
Okay, so we're going to hear from the Commonwealth now. It does not look like we'll finish this today because we'll be ending around 4
Okay, here we go with Commonwealth,
o'clock.
guys.
Hear you, Mr. Brennan.
Attorney Alessi ended his argument
Okay, so this is Mr. Brennan, just to be clear. So here, and you can hear the difference in the nasally
of
voice.
the Sixth Amendment and discounting repeated or repetitive violations. When you consider the conduct of this case, you should consider the history of the case, including repetitive violations, 3.6 violations, protective order violations, and then discovery violations, representation violations. The defense in the first trial attempted and successfully did portray ARCCA witnesses as wholly independent, presented themselves as oblivious to the nuances of ARCCA, left the impression that there was no compensation, no bias, no collaboration. They postured the information that they gave in advance of the second trial, and I won't get to the timing of that, but it ignores entirely withholding this information before the first trial. The defendant presumed innocent has a right to a fair trial, and so do the people of the Commonwealth. It is clear from a reading of the transcripts and the records and the posturing materials that there was information that showed that ARCCA was not wholly independent. It's information that was known to the defense,
No,
and for whatever reason, perhaps a strategic advantage was not provided to the Commonwealth, the court, nor the jury.
that's
Mr.
not true.
Attorney
It
Alessi talks
literally,
about the Gonzalez case. In that case, there was one attorney to cross-examine a witness, which is protocol, another attorney passed a note, a minor violation of a court procedure.
I don't know what you're talking about, Roland. This is the court TV feed, so I don't know what you're saying you missed. There was a moment when Mr. Alessi was trying to jump up and say something. It looked like earlier, a second ago. I guess the camera was pointed at Judge Bev, so maybe you're right about that. Like the camera was initially pointed at Judge Bev when he started talking, but I don't know why there would be a different. I mean, the court feed is the court feed. I don't know why anyone would have a different angle on this, so I'm not quite sure. Yeah, I mean, you can see it's court TV, so.
That is like a raindrop in a hurricane. We have a code of ethics and rules to ensure a fair trial for everybody, both sides. Coming in at the last hour and providing information when the avalanche has started is not enough. This isn't just about Rule 14. My effort with the ARCCA witnesses from the beginning, and I've been clear and consistent, is not to preclude them, is to get fair discovery that we're entitled to. I did not know before a few weeks ago what the defense had known. I did not know that there was conversations and efforts made between them and then inevitably conversation made. I didn't know that, but I certainly suspected it. I saw your Honor's questions before voir dire, during voir dire, after voir dire. I remember the conversations at the sidebar. And those questions were right to the point. And when we were sidebar, I specifically mentioned, I don't know about voir dire is inconsequential. I don't know what to ask. I can't send them back home to get their records or their emails or any billing. All of that was denounced. All of that was portrayed as baseless. But the court had questions. I had many of the same questions. It is not a surprise that we start to scratch off the tip of the iceberg. It is not complete. There is a murky relationship between the defense and the United States Attorney's Office relative to these ARCCA witnesses, and there is a very unclear relationship as we stand here right now between the history of interaction between the defense and these ARCCA witnesses. You can see from the emails, while there is some information provided, there are gaps.
So now, oh my God. All the times he said, I want to stop them from coming in. What does this sound like to you? There's a very murky relationship. What does this sound like to you guys? Does this not sound like him trying to stop them from coming in? You've got to be kidding me.
There are enormous gaps in time. The pause moment on March 24th and then reinitiating on May 5th, where ARCCA is actually billing the defense for their works before the voir dire.
Okay.
There had to have been communication between that time that rekindled this relationship. There are attorney requests that are mentioned in the emails. We didn't get all of those responses. And so we do not have an affidavit from either counsel or any of the counsels. We did not hear a word from any of them. According to Alessi, what you should do, what the court should do, is go to the federal government and ask
So
questions.
just to be clear, I am not having expedited communications with anyone about this case. So I'm totally rejecting your request that I do that, Mr. Alessi.
It wasn't a question.
You suggested that I call them.
No, I said if Your Honor wanted to do that. I didn't suggest that Your Honor.
I'll move on, but the point is
Wow.
not incumbent on the court to provide the proof that the defense was given the opportunity to bring in today to clarify the record. Instead, it is the typical 101, blame everybody but themselves, no acknowledgement. There's no
That's not
contrition,
true at all.
and there's no confidence that we are
Contrition
going
for
to get all the
what?
materials that we're entitled to.
Oh my God. Oh my God. No, he's definitely doubling down. This is crazy. This is crazy. Oh my God.
To suggest that ARCCA's position did
Wow.
not change, it did change. Their opinions did change by the time they reached trial.
No, they didn't. Oh my
It is not
God. What?
that the defense brought out that there was an expert in lighting or crashes happen at night. It is the bias, the relationship that is critical, and that was hidden from the court, the Commonwealth, and the jury.
If that's what you thought, then why did you bother even bringing the shit up about the lights and the pedestrians? Twice.
It is the bias and the leaning towards one side that was not disclosed in the first trial. It was disclosed last week or 10 days ago.
He's doubling down, but he's not only doubling down, he's doubling down and completely changing his argument and what he like. This is crazy. It's like it went from here's the things that matter that bother me about like the lighting and the blah, blah, and then like, you know, and also we want them to testify. We're not trying to, and now it's like, what?
Let me offer a quick history. It is true. When I first spoke to the court, I believed the documents provided by the federal government, and I did correct that record as soon as I learned before court.
No,
ended today.
stop it.
January
That's
30th,
gross.
2025, the United States Attorney's Office responded to one of my 2 requests. They provided billing, including ARCCA billing. There was billing for their reconstruction, but there was no billing provided for their preparation, for their preparation, travel, expenses, trial testimony. That information was provided to both sides on January 30th, 2025. It seemed at that point that the federal government was being at least a little more responsive, although not directly.
And it's funny. That was another question that I asked last week. As I was like, well, you know, there has to be a separation between being paid for their work as reconstructionists. We know that's with the government, right? But then, like, there's all these other things, right? So work done at trial versus their work done prior to the trial, which was the work that they were doing on like the research, you know, the car shit, right? The physics.
Bills other than what the ARCCA experts did in putting together their demonstration and their accident reconstruction. February 11th, I filed on behalf of the Commonwealth a motion to exclude the ARCCA witnesses. On February 12th, the United States Attorney's Office gives us new emails. And those emails were between the defense and the United States Attorney's Office regarding their request to use ARCCA witnesses at trial. It's not a surprise that on February 13th, on the heels of these more productive disclosures by the federal government, we then received the disclosures from the defense, which are the emails regarding conversations between Attorney Jackson and Dr. Wolfe, and the invoice for billing. Now, I did misspeak. I corrected it. But it is not the source of that information. It is the substance of that information, which is critical and relevant. It is that information that should have been known to the court, the Commonwealth, and the jury at the first trial. And it is also that information.
They hadn't been paid. Are you
The
joking?
representations that have been made prior to trial by the defense that has input. Before, and I'm not going to belabor this and go through the comments, most of them again, but it is important before I get to the representations. The court does consider pro ARCCA. We have one licensed attorney in Massachusetts who's carrying 3 pro ARCCA attorneys with the request for a 4th to ride on that same license. There is a responsibility, especially to Attorney Yannetti, fine attorney, an excellent attorney who I admire, but there's a responsibility so that there are not a number of pro ARCCA lawyers doing different things and then later plausible deniability. When we send emails, if I should miss one person on an email, I will receive an email telling me that make sure everybody gets every communication. I've been corrected or redirected many times when we've left somebody out on a communication. Pleadings are signed by all parties. They come through with our card on that table. And so to try to parse or miss or put a slight on words to suggest that things are done independently and there's no responsibility for the defense when a representation is made that's inaccurate isn't enough. It doesn't assure that in the future it won't continue. Now, Mr. Alessi said there were rules of the road. This was before his time and mine, but I read it. There were no rules of the road. There was a protective order. And the protective order was clear that there was no discussion outside of court about the federal material. And there was nothing in the protective order or direction from the U.S. Attorney's Office that the Commonwealth had any right or privilege to contact any witnesses. Everything is done by the book, by regulation, through 2 requests.
So I have to say, I've never seen the protective order. I received a stack of discovery that the federal authorities were kind enough to get to me in advance of trial last time, because Mr. Jackson had told me he understood that I was operating from a place that I didn't have enough knowledge essentially of what was going on. So I received those 3,000 pages plus. I did not receive a protective order. I don't know that I'm entitled to it, but it would be helpful. I don't want to take it if I'm not entitled to it. I don't know what the parameters are.
Your Honor, we have a copy of the protective order. I did ask full counsel if there was any limitations to it, and I don't have a certain answer. What I'd like to do is
Call over
inquire.
there, please. All right, if I can have it, I'd like it. It would help guide me through this. If I can't have it, I'll just go with everything I'm doing.
We'll see the counsel.
Sure.
Okay. You want to speak to
The
counsel?
United States Attorney's Office can give an answer.
All right, I appreciate that.
Okay, Klein, you
Sorry to
can.
interrupt.
And so the portrayal that there was a rules of the road, there was no such rules of the road. Neither Attorney Lally or McLaughlin ever contacted any witnesses directly because they understood that that was precluded. And so there was not an opportunity to call or discuss or have conversations, share direct examinations, or have emails with these witnesses. In fact, it's underscored, isn't it, by the emails that we received where Dr. Wolfe replies at the 24 saying the U.S. Attorney's Office essentially told them to hold off on communications. It doesn't seem like it would be a pretty clear rule of the road to have independent conversation with these witnesses and then be cautioned that that no longer was viable. And so inevitably, it was the understanding that nobody would be speaking to the witnesses. And I did see in the transcript, the board there was asked, were you available to the Commonwealth? And the witness said yes. I don't know any basis whatsoever for the witness to suggest that there was any invitation to speak to them. And so what we have is we have witnesses that were wholly portrayed as independent. When we look at the testimony, it was represented many times in court, leaving the impression that the defense had no access and no special relationship with the ARCCA witnesses. On June 5th, 2024, day 26 of trial,
What date?
day 26
You
of
know
trial,
that, what date?
June 5th, 2024, discussing scheduling and voir dire hearings. The defense said, I provided everything we have. I can't make up discovery. I mean, I got a report. And everybody in this room knows why I can't provide additional discovery for ARCCA. Everybody knows they've got what I've got. Your Honor asked, I haven't. If you can't, that's fine. So not everybody knows and I make those decisions. Response, certainly. You're the one who needs to know, and I thought you knew. The federal authorities will not allow me to interview or ask for additional information from anybody in their world. So I have nothing. I've got a report. He's got the report. That's it. I'm going to start asking questions on the report. That's it. He can cross the report. So as many times as he says, I don't know what they're going to testify to. Yes, you do, because they're going to testify to the contents of the report. And those are definitely questions I'm going to ask. So I've got clean hands.
All right, so you're reading from a transcript, as you know, there are dozens of transcripts. What's the volume number, this date, I'm sorry, what's the volume number and the page number?
Day 26 of trial, page 248 to 250. I will get a volume number for it.
That's okay.
This seems to directly contradict the theory that Attorney Alessi has been promoting today of the rules of the road. This does not suggest that ARCCA is open for business and private discussion and consultation of payment. It says the opposite. It says the opposite. The federal authorities will not allow me to interview or ask for additional information from anybody in their world, so I have nothing. And so this presentation today by Attorney Alessi, suggesting somehow
Why is he
that
saying the
this
thing
was
wrong?
open and notorious, is not backed up by the defense attorneys themselves. The June 10th hearing, we've already been through it. I won't repeat it, but those comments are important. I think what stands out about the prior hearings, and I say that I think that there's a murky relationship that we have not done more than scratch the surface of, is Your Honor may remember that the defense noticed 3 experts, including Mr. Klein. When we get to June 10th, Your Honor is asking, regarding the 3 experts from ARCCA, this is June 10, 2024, trial transcript 28.
Yeah, they weren't calling to third group. They weren't calling to third group.
I believe it's page 12.
Okay.
And you were asking about the 3 experts from ARCCA. And you mentioned, notably, I can't tell who does what or what the basis of the opinion is. When you look at the ARCCA report, there's no delineation on which of the 3 experts did what in that report. You can't tell what role each of them played from the report. And so if we only had the report, we wouldn't know which of those experts to call.
That was why.
So when you continued questioning, you were told, well, you said, so I'm to believe that the defense is calling 3 witnesses that you've never spoken to and putting them on the stand. And Mr. Yannetti said, that's essentially it. He gives some detail. As mentioned earlier, we've spoken to them only for purposes of coordinating their testimony and background. The important point for this particular point is that the defense inevitably calls 2 witnesses, Mr. Wolfe and Mr. Rental. And when they only call Mr. Wolfe and Mr. Rental, there must be a reason why. Because you can't tell from a report who did what. They noticed 3 experts. So there must be conversations with somebody explaining the witness's role or why only 2 of those 3 witnesses are important to the defense.
I feel
And so
though.
it's clear from the absence
I
of
feel though like that was talked about at the time, and I feel like he's leaving something out. I feel like they did. I feel like they did address why they weren't calling the other dude, but we'll see what happens.
information. There are much more communications
Like it would be a lot for him to misrepresent something else on top of all this, right?
that are expected to be in existence that have not been provided.
Liz, are you still with us?
On page, on June 18th, 2024. The voir dire hearing. The court asks, well, I thought that you would help.
I've got the transcript, what page you want? Do you know?
No, but I can.
If it's just your nose.
Oh my
I
God.
can pull that up.
We could also use Mr. Alessi's organized finder tab to find it that way. Wow. You know what's so funny? I think about all the times when she hurried Alessi along, when he was already prepared, had everything ready for her, and she's like, you don't have to say that. Like, don't tell me what you're going to do. Just do it. But look, think about all the time he saved her because she could go directly. And now you've got Brennan, who's disorganized and doesn't have the shit ready, and she doesn't complain at all about how much time this is taking. Remember, this is on 1.5 speed, so this is taking a lot longer than it seems like for her to find whatever it is because he didn't have it ready. Just saying. Like, really, though?
Page 4, line 11.
God damn it.
So the understanding of the voir dire is that if this is for the Commonwealth's motion to exclude this testimony, all right, that's what we're here for, the Rule 14 violation. And Mr. Jackson says, is that the same with Dr. Wolfe and Dr. Benchler? And the court says, well, I thought that about both of you. The Commonwealth has nothing on that, and you say you haven't been able to even talk to them at all about this case. And the answer is that's correct. Now, refrain from my opinion and characterizations. On my defense, I think that the transcript speaks for itself. I'll let it speak for itself.
It's entirely possible that the third dude just wasn't available, right? We don't know. He's doing that thing again, and we're not going to know until we hear from the defense. But it's entirely possible that the other dude, and again, I remember them talking about it a little bit more at the time, but he just was reading from the transcript. Although, having said that, it's not out the realm of possibility he left something out. But I wonder if it was just because the dude wasn't available. Like, I remember when it was, I remember when the question was brought up about the 3 dudes, and I remember thinking, wait, they already said they were only using 2. Like, that was what I remember that having come up, that they mentioned the ARCCA dudes, and they never said all 3, and then Judge Bepp being like, well, all 3 is in the report. And then Lolly's concern was with who did what. And then, they're leaving something out, because I remember I even commented on this last week, because we watched it last week, and I was like, after they talked about it at the hearing, Lolly was satisfied as to who did what. And so then he was like, that's fine then. So anyway.
When we continue in the voir dire hearing, page 71.
Okay.
Line 4, importantly, were you hired by the defense in this case? No, sir. Before this morning, when you walked in the court, had you and I ever met face to face? No, sir. Now, this illustrates an important point. That is technically true. But what impression is that making to the court and to the Commonwealth? Is that a genuine impression consistent with reality? Line 20, the person to my left, the female to my left sitting here, have you ever seen her before? Nope. Do you know who she is? Yes. And so there is direct and indirect commentary, questions, presentations that reinforce that the defense and ARCCA are wholly independent from each other. This is also consistent with the representations regarding payment. There are questions for there in the trial about whether or not the witnesses were ever paid. It may be technically true they were not paid at the time they were asked the question, but if there is an expectation of payment, it is a promise, reward, and inducement.
That was me.
It can show lies. There's nothing wrong with paying an expert. There's nothing wrong with going over a direct examination with an expert. There is nothing wrong with talking about particular questions with an expert. But when these experts are being portrayed a certain way, that they're independent, that there is no evidence, information about them, then it is not a fair representation. It is not an honest representation. Now, it wasn't until Your Honor asked today that we even knew that the defense paid this bill. When you look at the bill, there's some things that stand out. There's a tax ID number, an invoice dated July 12, 2024. It's addressed to.
Hold on 1 second, please. Okay.
It's addressed to Attorney Jackson. And the position that the defense takes, Attorney Alessi takes today, this came out of the blue. They had to pay. Apparently, everybody in the know knew the defense was paying for this expert, other than the defense. ARCCA experts knew. Dr. Wolfe knew. Dr. Benchler apparently knew. The federal government knew. When you look at the bill, there are things that stand out that are so notable that you can't go back and try to twist them or change them. Look at the first entry of May 1st, 2024. That is before June 10th. That is before the representation that there was no intention of compensation. Apparently, the witnesses they were going to call expected that they were going to be paid by the defense, so they wouldn't have been keeping track of their time back on May 1st, 2024, participating in telephone call with Alan Jackson. And so the March 20th email asking for an engagement letter and a retainer, and then the 24th saying you need to take a step back because of the attorney's office.
22nd.
I'm sorry, 22nd and 24th.
Oh.
There is obviously more communication because the relationship re-engages at least on or before May 1st,
Yeah,
2024.
Roll out.
And these
I never would have picked up on that. That is interesting, I guess, because we've all, people have been commenting, including myself, on, his voice is kind of nasally. That's interesting, though. Huh. Yeah, I would not have, having had his jaw wired shut. Interesting.
witnesses understand that they're going to be paid by the defense. And as I mentioned, in the materials we got from the United States Attorney's Office on February 12th, there is no billing related to track for air travel trial, none. So the only people who were surprised that they were paying the witnesses apparently was the defense themselves. And then before that June 10th hearing, where the representations were made, there's a June 9, 2024 phone call. Another participated telephone call down. And then we see before the voir dire testimony, there is billing to the defense, which is now being paid by the defense, prepared for voir dire testimony, June 17, 2024. What we don't know is, in the preparation, was there any conversation with the defense? Was there any emails? Were there any documents? Were there any outlines? Was there any discussion about the potential testimony, or was this solely the preparation of Dr. Rensler on his own? On the same day, 3 hours billed by Dr. Wolfe, prepared for testimony at hearing. Now, they felt inclined and comfortable billing the defense for it. Was there any interaction or discussion between the parties? We don't know. This was the time that the court gave the defense an opportunity to bring in their product, their receipts, the emails, to elucidate, illustrate, demonstrate, prove what the relationship was. We don't have anything. We have nothing more than we did last week. On June 18, 2024, a round trip to Norfolk Superior Court by Dr. Rensler, and also separately for his testimony, 8 hours billed, 12 hours of Dr. Wolfe billed to the defense. June 21st, Dr. Rensler prepares for his trial testimony, bills the defense, 5 hours. Again, we have no idea if that includes in any way correspondence, communication, interaction with the defense. June 21st, Dr. Wolfe saying prepares for trial, 6 hours. June 23rd, Dr. Wolfe travels to Boston for trial, significant delays, and then Dr. Rensler on the 24th, round trip, Norfolk Superior Court, 11 hours, 6.5 hours respectively, billed to the defense. Now, it's hard to believe these witnesses would put forward money and expenses and travel without some understanding that they were going to get paid.
Again, but remember, this is exactly what we were saying, and that I think even Mr. Alessi said, like, that they were keeping track of their expenses and their time because they knew someone was going to pay them, right? And nobody knew who, because the DOJ hadn't like reached out and like to the defense to be like, here's exactly what the situation is, right? Remember the whole pause email. So I mean, I think that's what it is. I think that's why they kept track of it. It doesn't mean that there was any agreement in place. I mean, that's what it looks like. I mean, if there had been an actual agreement, it would have been discovered, right? And so what we've seen is the totality of it. And it makes sense, right? Because this situation was so unusual that there's not really a procedure or a protocol in place for how to handle it. And I think that's why the DOJ paused it, because they're like, we don't really know what to do, blah, blah, blah. And then we'll, in the meantime, like you guys, yeah, they can go testify and then we'll figure it out, right? And we were all wondering the same thing, like, how are they getting paid? And I think everybody was wondering how they were getting paid. And then the DOJ figured it out and didn't tell anybody until they sent that bill after trial. That's what it looks like to me.
It is hard to believe this company, especially after receiving an email about engagement and retainer, especially after having conversations, collaborating on the potential testimony. It is hard to believe that they would come to Boston, spend their time and their own money to do this, to just simply send a bill later with no expectation of being paid.
Yeah,
And
now
in
that
fact,
you mention it, you can see that he does, he doesn't open his jaw very much when he talks, right? That's
it's very specific accounting of their time. And when one accounts for their time, it's because they need to have a contemporaneous record so they can get paid for that time. Also billing for wait time and travel, testimony at trial on June 24th, and then his expenses for June 18th and June 24th. Specific expenses, $1,749, $1,932. So they are keeping very careful track of the bill that they send. Within 1 month of the defense, they get paid that Commonwealth Court never knows about, Commonwealth correcting record. And so this $23,925, we find out today, it was paid by the defense. We hear that there was a conversation with the federal government. We have no affidavit, we have no witness. We have no right, no email, no correspondence, nothing to support, put in context.
Yeah, they need to talk to the federal government.
No.
Honestly, the federal government can clear this up And they already mentioned that earlier. They need to talk to the U.S. Attorney's Office. But they can clear this up. If they were to just be like, yeah, we hadn't made a decision, we didn't tell anybody anything, and then we sent that bill, and you know what I mean? Like, this is, you know.
So when you look at the story on this bill, and the timing of it and the details of it, we know that we are getting a fraction of the story. A fraction. It's not enough to blame the court, blame the Commonwealth, blame the Attorney's Office. This is accountability. In addition,
To me, right now, she looks a little bit more skeptical or trepidatious in buying his bullshit. I could be entirely wrong. I could be entirely wrong.
look at the totality, the representation made
But
for
I would hope that Mr. Alessi's argument, because that's what's called, right, raised a lot of issues for her as far as Brennan and resolved a lot of the things that were made, comments that were made last time. And I hope she's noticing that he's completely contradicting a lot of the things he said last week and completely changing his position on some of those things too. And it looks weaselly.
We also, at some point, we're going to address the Commonwealth position.
Yeah, I have seen it.
It's interesting that after the last court hearing, well-known reporter, very reputable reporter, Christina asks Mr. Jackson about paying the bill. And what I suggest more 3.6 activity, quote, no, of course not. That was the position last week.
Oh, wait, I missed that part and I did not see any interview. So let me see what that says.
3.6, that's the motion. It's interesting that after the last court hearing, well-known reporter, very reputable reporter, Christina asks Mr. Jackson about paying the bill. And what I suggest more 3.6 activity, quote, no, of course not. That was the position last week.
What he said is asks him about paying the bill. And then he says, no, of course not. Something's missing there. Because if somebody asks something about paying a bill, the answer, of course not, doesn't, words are left out there. So I will see if I can find that interview after we finish with this and see exactly what was said there.
So what we're left with is we still don't know the relationship between the defendants and ARCCA. We don't know about the impact it had on the first trial. There has been these multiple representations that ARCCA was independent, they had their opinions, and they were exculpatory. ARCCA's opinions changed. There were 4 opinions. And if you look at the report, and I'm not going to read it for sake of
they're
the
doing
press.
stuff over there. Because I was going to say, if that happened, well, okay, he left words out. If what was asked is, did you pay for the bill or are you paying them at all or whatever? And he said, no, of course not. At that point, I think that would, I mean, okay, that would be a problem. Now, the only thing is this, right? Remember, Karen Reed's office got the bill, you know, from the defense people. Like, he may not see all of that. Remember, Ms. Little handles the discovery. The bill goes to the office, which I don't know if that's Alan Jackson's office, but still he wouldn't be the one handling that type of stuff, you know? So I don't know, there's a possibility that it could happen and he didn't know about it. But I would think it could be a problem because that kind of dispute, I mean, that, you know, if he said this last week, right? But we don't know. We're gonna watch it and see unless they come back and address it. I don't know if they have time to do that today. With
We'll have a trial. We'll edit that trial.
That's funny.
When you read the report,
People say that all-
the representations made about that report were extended that trial. The question's going to be why? Why did they approve? Why did they?
Particular page, like, without site.
If you look at the first page.
Yes.
Yeah,
You don't have to read any of it, you just tell me the paragraph.
Yeah, I think it's the first paragraph that leaves other findings.
Thank you very much.
And actually, particularly note number 4, and both publicly, tentatively, but also at trial, the parameters of that were extended substantially. There's a summary again.
No,
at the end of that
Brennan.
report.
Brennan's from
It's the same thing.
Massachusetts.
If you look at the last page, which is signed by all 3 of the experts, Mr. Wolfe, Mr. Rexford, and Mr. Klein, says essentially the same thing.
Yeah, Brennan's from Massachusetts. representing the Commonwealth. Oh,
So we'd be oblivious if we stood here and said that
lots of people watch my
the
carving.
relationship between the defense and the experts, there's no relevance to bias or motive or desire to please, because clearly there's a change, there's an expectation of payment, there's communication, and to suggest that an outline was provided so close to the testimony, therefore it shouldn't have been shared, it isn't just what's in that outline, it's the fact that they have the relationship. Attorney Jackson may have brought out that accidents happen often at night. It's not the point. The point that the ARCCA witness is willing to forego that information as a benefit to the defense. That is the heart of what is missing and what is hidden. And so there are a number of instances, three of them, in the outline where the ARCCA clearly is trying to accommodate the defense. And by representing to the court that there is no relationship, the hands are clean, they have no information, is not only not accurate, it is misleading and unfair.
I was saying that like lots of people listen to my guitar videos like that. I mean, that's why, it's music. So people listen to music and they'll listen to it more than once, right? You know what I mean? But yeah, people say all the time that they fall asleep listening. I don't know, but I don't know if they're referencing a live stream or a guitar. Sometimes people will be like, oh, I'm falling asleep like during the live stream, and then they wake up and then they're like, you're still streaming. I'm like, yeah. But yeah, anyway,
Well, there is more. The question is, will we get it before trial? I have another TUI letter going out this week. I don't know how long it will take to respond to it, and the TUI letter is not going to be thorough. It's just not the way TUI works. And so we are in the same spot. Well, actually, we're in a better spot. We know now about the relationship. We know about the potential bias. We know about the payments, but we don't know the full scope of it. And so we are entitled
examine them on
to that
it. Be
information.
done with it, dude.
We don't know what conversations, communications the defense had with the ARC experts that the federal government doesn't know about.
Let's examine them on it. If you're so
Over the next few weeks, we're going to attempt to get more information, but we will never have an accurate accounting unless it's compelled. Your Honor mentioned the sidebar,
Which one?
the most recent one.
Okay.
I am not trying to be overly critical of another attorney.
Oh dear.
I'm not.
Oh dear.
You can laugh, but I'm not.
Oh,
my effort to get what
oh fuck! She laughed at him for saying that. Interesting. Is she done with this BS? Oh, that's cool. You started playing the accordion. Awesome. That looks like hard. That looks hard. I've never played one, but it looks hard. Wow. She laughed at him, which we can't see her, but he says you may be laughing. Holy shit! Because he's about to be. Wow.
I am not trying to be overly critical of another attorney. I'm not. You can laugh, but I'm not.
Wow.
It has been my effort
Well,
to
it
get
it could be that it was the defense table that was laughing. We don't know, unfortunately.
working material. It has been my effort not to exclude ARCCA witnesses. It has been my effort to try to achieve.
Are you gonna ask for it now, though?
There's been no other way to compel any information other than to file motions in this case. And it is not incumbent on the government to fight for this information. We're entitled to it. We're entitled to it. And at this point, we have no confidence whatsoever, none, that we're going to receive the information that we deserve.
Here we go. Yeah, I'll replay it again. Dude, he wants those ARCCA people off. I think his whole thing was he wanted to be able to come in here and be like, after that whole interview with the juror and everything, he wanted to be able to come in here and be like, yeah, we're not afraid of the ARCCA dudes. Why would we care? It's fine. He wanted to be able to come in here and make those statements. And then now he's coming back to obviously, well, there's no other way. So that it's like, you're going to have to exclude them. But dude, it's so weaselly. Okay, I rewound it. That part.
I am not trying to be overly critical of another attorney. I'm not. You can laugh, but I'm not.
See, the reason the second time I was like, well, maybe he's laughing or he's talking to defense tables because he kind of turns his head there. Initially, I thought it was Judge Bev, but he kind of turns his head like to the defense table. Could be either way. I don't know. Let me know what you guys think. We can watch it at normal speed if you want to get a better idea of that. Or yeah, let's just see. We'll bump it up after. But interesting gesture. I mean, I was laughing in my head or out loud. I don't remember, but like, yeah. I mean, because he's doing that thing he does, right? It's just so stupid.
I am not trying to be overly critical of another attorney. I'm not. You can laugh, but I'm not.
Huh. It's hard to say. I think it could be the judge. It could be defense table. It's hard to say. I don't know that even slowing it down actually helped determine that. But anyway, so yeah, there you go. Somebody was laughing. Yeah.
It has been my effort to get more working material. It has been my effort not to exclude ARCCA
Oh
witnesses.
yeah,
It's been my effort.
I think we think he was actually finished and about to sit down where we left off. So
Not that we're going to receive the information that we deserve.
all right,
Thank you. Mr. Alessi, very briefly, if you have something.
Yes, thank you, Your Honor. I'll be very brief.
all right.
And I hope we get an opportunity to have more.
Oh.
I'm going to be very brief on the 2 points.
Okay.
Attorney Brennan focused a lot on the invoice. As I said, I work with experts all the time. The experts keep track of time. They have historically been paid by the government. There's another completely rational, more probable explanation that they have been retained by the government. They were being paid by the government.
Mhm.
They maybe at a certain point didn't know who was going to pay their bills because
Yep.
if they turned out they were going to provide testimony. That's a whole different issue, what they expected
Yep.
to be paid and by whom from what the defense expected. So two things can be true.
Yeah. And that's what I said.
It can be at some point they thought they were going to get paid, but up to that point they were being paid by the government. And the entries, all that Mr. Brennan went through, particularly the early ones, there is zero evidence before the court on any basis that they expected on those days of those entries that they were going to be paid by the defense. And it's very important because Attorney Brennan spent most of his time on that invoice. With regard to the comment he made, and this is the problem when we don't have notice, like I provided a notebook so everybody can see it. We don't have some of the things that Mr. Brennan was referring to, but he referred to the whole things. Mr. Jackson's response to a reporter. When you're talking about communication.
Okay. Excellent. Literally, remember, guys, it was just a second ago. I was like, what? He left out word. Okay. I'm glad he's addressing this.
It's a report. But to be clear, the reporter asked, did you pay for testimony? Did you pay for testimony? Mr. Jackson, of course, said, no, I paid for their time.
Did he say I paid for their time?
Pardon me?
Did he say I paid for their time?
Mr. Jackson?
I said the words, of course not. Did you pay these witnesses for their testimony? And I said, of course not. The court would ask me that question today, I would respond exactly the same way.
All right, so you just told that I paid for their time. That
No,
was not said, right?
That was not said, but I'm saying there's always some inference about these what he said, that what was said, but that was his response, that was it. But it was only, the premise of Attorney Brennan was, what Mr. Jackson said to the reporter was different from what you've heard in court today, and it wasn't. It's important to be accurate. The other things I'm going to go through.
Like I said, I was like, he left out some words there, so he didn't have to ask.
Quickly, is it kept stating that there had to be a belief that they were going to be paid by the defense. There is no evidence whatsoever for that because it didn't exist. So now with regard quickly again to the other topics. Attorney Brennan talked about 3 witnesses, right? And he said I believe I took it as clearly inferring 3 ARCCA. Your Honor can go back to the transcript. It was Dr. Russell was the 3rd one.
Oh, I thought it was the 3 ARCCA people. I can go back to the transcript.
You can go back to the transcript. Earlier on, there was a discussion way early on.
Who is this to confirm?
Okay, now it all makes sense. Because remember, guys, I was just saying, I was like, wait, they settled that issue. I remember them settling that issue about the other ARCCA dude. Oh my God. He misrepresented that too. Because they do come back. Again, we watched this last week, okay? This June 10th hearing. They do come back at the end, and she does bring up Dr. Russell. And it is clear that that's who they're talking about. Oh my God, did Mr. Brennan misrepresented that too? Oh my God.
He was a 3rd ARCCA expert that was involved for the government, right? And then he stopped, and we didn't retain him for testimony. Let me be clear on what I mean by retain. He didn't testify. He didn't. I understand. I'm trying to answer your question.
I know, and I realize that you just said something that you want to explain. Go ahead and explain.
Right. So what I'm saying is, in terms of, I'm going to take back the retain. The point is, there were originally 3 ARCCA persons on the report that we got from the government, right? Rentschler, Wolfe, and Klein. We only went forward with the testimony of Rentschler and Wolfe. And that's what I want to come to, Your Honor. The whole emphasis was that the Commonwealth had no notice that we were going to use these experts. Your Honor, the voir dire was the notice. And my point was, I didn't say that there was no bias. What I said was, once you decide you're going to use an expert, right, you're going to be having them testify. Anybody could claim that that testimony is biased. But the point is, Your Honor, that the allegation that somehow mysteriously this 3rd person was being discussed, and clearly the inference was that we were misrepresenting still about which ARCCA witnesses because we were talking about the 3rd. The 3rd was Dr. Russell, and you'll see that in the transcript.
Okay, but when I said.
So it's another misrepresentation by Brennan.
You expect something, whatever I said, you expect me to believe that you were calling 3 witnesses whom you've never spoken to.
when I had that discussion with Mr. Unity. That's what I meant.
Thank you for bringing that up, Your Honor. And that was just ARCCA. That was nothing.
That's a different part. That's at the beginning of the June. How do I know these things better than she does? Okay, that's at the beginning of the June 10th hearing. That's different than when it's brought up again later with the 3 people, but it's with Dr. Russell.
With Dr. Russell. But here's the important part. Attorney Brennan didn't read the rest of it. You're
Right.
Okay, so where are we? Are we the June 10th?
Yes, please, Your Honor. June 10th. That's exactly right. That's exactly right. With June 10th, it's important. He stopped when he made.
Page 12.
Yes, thank you. So on June 10th, so you're to believe this is line 19. So I'm to believe that the defense is calling 3 witnesses that you've never spoken to and putting them on the stand here. Here's the response in its total. That's essentially it. We've spoken to them. So it's not like it wasn't disclosed there was a conversation. It was. We've spoken to them only for the purposes of coordination of their testimony and their background. We've not been able to interview them regarding their findings, which are outlined in detail in the reports. Your Honor, that's 100% true because
I
I
read that earlier.
right, but Mr. Brennan just mischaracterized it again because that is 100% true. He made it seem like that was an untruthful statement, and I know Your Honor gets it. The other last 2 points, Your Honor. Attorney Brennan talked about that the ARCCA experts improved their testimony. My point, Your Honor, was their opinions never changed. Whether they improved is a characterization, but their opinions did not change. And that is very important. And the last point, Your Honor, goes to the discussion that Your Honor was having with the questioning of Ms. Little, Mr. Jackson. I want to be very clear on February 6th, and this is going to be my very last point. When Your Honor asked the questions on February 6th, and Mr. Jackson responded about the discovery, and I said to you that Ms. Little was the one handling the discovery. And I spoke with Ms. Little and I spoke with Mr. Jackson, and they're going to be completely available for any questions that follow up on this. I asked Ms. Little during the break. She wasn't here for that February 6th. She obviously didn't hear the sidebar. But I said, when you learned of what Judge Cannoni was asking about, I said, in your head, what was going on and what came to your head? Because I said Mr. Jackson didn't make any knowing misstatement because he had no recollection of any of those March emails. So I asked Ms. Little, who would, between the 2 of them, would, if there was any recollection. So during the break, I asked Ms. Little, I said, Ms. Little, when you heard and got the order, because that's the first thing you do in English, she gets the order. I said, when you got that and you saw that you had to turn over discovery, when you read that, did it come to your mind? Did it come to your mind that there were these March emails? And she said, no. I didn't recall them. I didn't remember their existence. And what I did was I knew we had to turn over discovery. I then went back, I rediscovered those emails, and that's how I had recalled it. That is important, Your Honor, because there has to be a knowing misstatement of fact for 3.38. So not only did Mr. Jackson not know at the time Mr. Jackson made those statements and recalled those emails, neither did Ms. Little, who was the keeper of all the discovery. And that is my last point, and I will conclude this way, Your Honor. Attorney Brennan conflated Rule 14 issues with the 3.3A1 issues. They are completely separate. I am not here today, Your Honor, to take.
I just wanted to say real quick, I looked it up. I can't find a video of that interview, and it doesn't look like one exists. It looks, and no one's even like quoting it exactly. It looks like it's just sort of like Mr. Jackson spoke with a reporter or whatever, like as he was leaving. And so, and it looks like that the reporter asked him about, did you pay? And I looked on a couple different sites to see if they all said the same thing, and they did. And it was like, did you pay the ARCCA dudes to testify? Right. This is like what Alessi said as far as the question, but not like what Mr. Brennan said. So it's like, did you pay them to testify? And his answer was absolutely not, or of course not, which is like exactly what he said in court. Didn't pay them to testify. And so Alessi's was saying paid them for their time, which you can understand that to mean it's like you didn't pay them for their testimony. In other words, you paid them for their time. So, but Jackson's answer is even better, right? Because just of course not. So that is what Jackson represented is what I read. Now it did say on one of those sites that they asked for him for an interview today and he didn't give one. I don't blame him. Especially if it's a situation like that where it's like in passing and it's not going to be recorded on video, right? Because you can see how maybe that would be stressful now. And what else was I going to say? I forget. Maybe I'll think of it.
Position that the defense is in perfect compliance with Rule 14. We're not. But that's a whole different question from whether the attorneys are in compliance with 3.3A. And I would urge Your Honor, as I know you will, to keep those distinctions as we go through the matter, because conflating them is not proper for the analysis. And my last is a citation of law, Your Honor, which says that Gonzalez involved a very minor issue. Attorney Brennan is correct. There was a minor issue in Gonzalez.
I remember what I was going to say. I was just going to say real quick that the thing is, if you're practicing before Judge Bev, right, and you're the defense, I just find it hard to believe that they would think that they could, and I don't think they would anyway, but I'm just saying for any defense attorneys, I would think that that you're going to be severely prejudiced from the get-go, and that even if you don't do anything wrong, you're going to be prejudiced, and that it would be like between both sides, right? Who's going to be more likely to get to do something and get away with it or whatever, or be free? Obviously the Commonwealth, right? In fact, the opposite is true. The defense is always going to be excoriated, even if they don't mislead the court or whatever. And so when you think about how much harder they have to work to be transparent and to turn things over and to be accurate with their representations and all that, whereas, she didn't fly off the handle and get pissed off at Brennan today. You know what I mean? It's like, it's just the bias, right? But when you consider how much bias there is, that changes. If you're an attorney in that courtroom, that changes how you're going to handle situations because of the judge, right? So that's what I'm saying.
But the Supreme Court went through those things that could rise to it, and I'm going to give you another site, Your Honor, which is United States versus Diazzi. That involved a lot of serious issues with regard to conduct of counsel. They were not pro hoc vice, but it's 807 Fed 2nd 12 First Circuit 1986, where Your Honor can read it as to what were happening. The attorney's conduct was deplorable, and yet the court held that you could not disqualify them because of the Sixth Amendment. And my last point, Your Honor, is when you do a Sixth Amendment analysis, whether or not the attorney at issue is pro hoc vice or not, is not weighty in the determination of balancing the Sixth Amendment. It is not. In the abstract, Your Honor, in civil cases, is it easier to knock out a pro hoc vice? That would be absolutely correct. But when it comes to a criminal case where defendant their choice of counsel, that is a much different analysis with the Sixth Amendment. So I will stop there, Your Honor, because you said to be brief. There would be more I would have to say, but those are the highlights for the moment.
Anything, Mr. Brennan?
Very briefly.
Not him again. God damn it.
My arguments to the court have always been focused on Rule 14. The verbal gymnastics that counsel engages in to use words like misrepresentation to distort reality is extraordinary. So let's use the defense words themselves. If you look at Docket 505, which was signed in a pleading.
That was filed late, right? The
February
Saturday or something.
The problem is this: if he keeps misrepresenting things, they would be in this courtroom and they would be there indefinitely, because if he misrepresents something, the defense has a right to address it. And that already didn't happen last week, right? So he better not misrepresent something again.
In 2025, this sums it up really. And this is signed by Attorney Jackson, Attorney Alessi, Attorney Netti, certificate of service by Attorney
Was
Little.
it signed by Ms. Little? It's not.
Ms. Little was
right?
only done
It's
certificate of
authored
service.
by- Okay.
She did not sign it. It was signed by Attorney Jackson, Alessi, and Netti.
Already.
And this is the defendant Karen Reed opposition to Commonwealth's motion to exclude employees of ARCCA LLC. And here's the representation they made. Not my words, not a misstatement, not a distortion. This is their words. Now comes the defendant Karen Reed, Ms. Reed, and respectfully.
That's interesting. Did you guys hear that? He just said not a mistake, not a distortion. As in, this time I'm not misrepresenting it. What? What? Well, wait, you would only, dude. Not a mistake and not a distortion. That's like a clarifying statement because it's different from what you were saying before. Holy mackerel.
To exclude employees of ARCCA LLC. And here's the representation they made. Not my words, not a misstatement, not a distortion. This is their words. Now comes the defendant Karen Reed, Ms. Reed, and respectfully request that this honorable court deny the Commonwealth's motion to exclude the expert testimony of employees of ARCCA LLC named Andy Wolfe, PhD, and Andrew Rentschler, PhD. Here's the important part. The Commonwealth's motion to exclude these exculpatory expert witnesses who were not hired or paid for by the defense. It is not made in good faith. It is a desperate and transparent attempt to keep exculpatory testimony of neutral expert witnesses from reaching the jury in this case. I know Attorney Alessi no longer likes the word retain, but that retain word has import. The reason he said their word, their motion. This is no different than the tone of representations made February, last June, May, and before. Thank you.
All right. So we're back here next week. I believe we're back here Tuesday, Wednesday, and perhaps Friday. Is that accurate?
I want to hear that last part again. Real quick.
The court denied the Commonwealth's motion to exclude the expert testimony of employees of ARCCA LLC named Andy Wolfe, PhD, and Andrew Rentschler, PhD.
I know.
Here's the important
I agree.
part. The Commonwealth's motion to exclude these exculpatory expert witnesses who were not hired or paid for by the defense is not made in good faith and is a desperate and transparent attempt to keep exculpatory testimony of neutral expert witnesses from reaching the jury in this case.
Why is he saying the word retained? That's why I want. So, I'm really confused. Is he's
And here's the representation they made.
okay?
Not my words, not a misstatement, not
So
a
this is-
distortion. This is their words. Now comes the defendant Karen Reed, Mislead, and respectfully request that this honorable court deny the Commonwealth's motion to exclude the expert testimony of employees of ARCCA LLC, namely Danny Wolfe, PhD, and Andrew Rentschler, PhD. Here's the important part. The Commonwealth's motion to exclude these exculpatory expert witnesses who were not hired or paid for by the defense is not made in good faith and is a desperate and transparent attempt to keep exculpatory testimony of neutral expert witnesses from reaching the jury in this case.
Hired or paid for. Okay. Literally, he was just reading hired or paid for. But now,
I know Attorney Alessi no likes the word retained, but that retained
retained.
word has import, is what he said.
Literally, what? He just said that they said retained and they literally didn't. What? I'm so confused. I'm so confused. I thought slowing it down, I'd be like, maybe I'm missing something. Huh? It said he's paid or hired. I think he's reading from one of those recent motions. Okay. So just to remind everybody, the Commonwealth's motion to exclude the ARCCA dudes was because it had to do with the discovery, right? And in the motion, you know, he was like, I'm not trying to get rid of them because of their testimony. It's because we don't have a discovery, right? Of course, in their motion, there was never any mention about what he brought up last week at the end, right? So I just want to hear it one more time just to make sure, because this is crazy. Like, does he have a problem with it in his brain where he like just reinvents things on the fly and thinks that he's not doing that? I don't know. What's the explanation here?
And respectfully request that this honorable court deny the Commonwealth's motion to exclude the expert testimony of employees of ARCCA LLC, namely Danny Wolfe, PhD, and Andrew Rentschler, PhD. Here's the important part. The Commonwealth's motion to exclude these exculpatory expert witnesses who were not hired or paid for by the defense is not made in good faith and is a desperate and transparent attempt to keep exculpatory testimony of neutral expert witnesses from reaching the jury in this case. I know Attorney Alessi no likes the word retained, but that retained word has import, is what he said. Their words, their motion. This is no different than the tone of representation made February, last June, May, and before. Thank you.
So he wants to represent that they are retained, although that's not what their document says. So what the fuck is wrong with him? Why does that matter? Because essentially, okay, let me explain this. So remember, a lot of this had to do with like the confusion around the fact that the DOJ was like, you know, you can't have any more communications, like the pause email, right? Thinking about the pause email, right? And it's like, okay, so now nobody really knew what was going to happen. Remember, like Mr. Alessi said, they didn't even know if they were going to be testifying, and then they were, but then nobody really knew who was going to be paying them, you know, and it was all, and I understand, because again, with bureaucracy, right? It totally makes sense that the trial's more important. You're not going to just wait for that answer. The trial would be over, right? And so all that makes sense. So what's the difference here? Why does the word retain matter? Well, first of all, again, he was trying to represent, he's like, I'm going to read this verbatim and I'm not going to misrepresent it. And he read it verbatim and the word retained wasn't used anyway. But regardless, the reason he's interjecting that word is because it's the only way around it. Because it's in other words, he's conceding that they weren't hired or paid. Because there was no financial arrangement in place, right? That they came to testify to what they knew from working for the feds, and it wasn't until afterward or whatever. The difference with the word retained is that the word retained is for him to get to work. It's a workaround, right? Because in other words, is so interesting. Let's just say that if this is what happened, and it's not what happened, we don't have any, there's no documents to support this. Let's just say it's for hypothetical. If what had happened had been this, what had happened was they're working for the DOJ and they're like, pause email, right? Okay. And then it's like, okay, before they came to Canton, right? Before that happened, if what had happened had been, they had a communication, right? Where they agreed to testify at trial and where there was some sort of arrangement spoken of to where it's like, you'll get paid after, for example, right? Like what normally happens when you have an attorney on retainer. It's like, I've agreed, I've retained you, you're hired by me, and there's an agreement that you'll get paid at a later date or whatever, right? And so, like, if there had been an arrangement made to where they were going to be hired and then paid after the fact, right? And why would somebody do that? Well, it'd be so that you could be like, oh, we weren't paid, but then it's like it's a technicality, right? That's where that's what the difference is here and what matters, because it's like the question would be, were they just trying to have a workaround? By they, this time I mean the defense, as in to be able to say they weren't paid, but they were actually paid, right? That's where retain comes in, because if they were actually retained, then that would be done knowingly, that you could say they weren't paid, but does that make sense? It's like, it's a semantics thing. Now, the thing that matters here is, remember, there's no communication at all and documentation of any of this. And I loved what Mr. Alessi said. It was a really good point that in the opening statements, this was never talked about. And it, you could tell they were shocked when it happened. I mean, remember when all this happened during trial and everybody was surprised, right? There were a number of, Dr. Russell was also a surprise. And so, when you think about the opening statements, but then when you also look at the communications, and again, they can clarify this by calling that dude at the DOJ or the U.S. Attorney's Office and finding out more information that way. But at this juncture, that is Mr. Brennan coming up with this new argument on the fly to spring it on them last week, right? That this was not part of any of the motions. This was not expected. And then, exactly as Rollo said, doubling down, which is shocking. I mean, really, to me, shocking. And I think that if it wasn't for the fact that it's Judge Bev, I don't think we would be seeing this. Even if all the attorneys were the same, but we had a different judge. Again, like I said, right? How can you be so fearless in terms of breaking all these different rules and then doing it again? And it comes down to the judge. That's the only thing I can think of. Now, who knows? Maybe he will get in trouble. I don't know. Judge Bev's going to take under advisement because that's what she always does. It's so annoying because this is crazy, right? Like, what is she going to do? I mean, we have to be prepared. I say we collectively have to be prepared for her to rule on this and to be like, yep, I agree with what Mr. Brennan says, like essentially, and then to punish that. We have to be prepared for that because that can't be a surprise, right, with her. Now, what might it be? Again, I would really hope that she's not going to punish Karen Read. That would be a big problem. If the Commonwealth is successful and God forbid somehow gets some sort of a verdict for guilty on any of the counts, it would be a big issue on appeal. And I'm sure Judge Bev knows that, right? So like what Mr. Alessi said, if you do find that there was any type of issue, deal with it after trial, right? And what is that going to look like? That's going to look something like, a fine, they have to pay a fine or something like that, right? That type of sanction. But I feel like that's not, I want to see Brennan go down. Wow. What a cliffhanger. This is an insane cliffhanger, honestly. This is an insane cliffhanger where it's really hard to say. To me, it's like it seems so clear what should happen, but then you've also got how Judge Bev acted last week, and then we know her history and we know how she is. And it's like, oh my God, right? Hey, Meg! Meg said she heard another lawyer say if she's going to punish the defense, she needs to punish. Needs to and will are different. And that's the thing, but I'm happy you're here. I would agree with needs to. That's not the question I'm asking. I'm asking what will she do? Because that's a completely different question. I think she needs to punish Brennan. Regardless. I think if she wants to punish the defense, she also needs to punish Brennan. But what will she do is a completely different fucking thing. And they probably, I'm sure they do, Rolo. It's just that it's hard to get that information from them, from the feds, right? The DOJ is going to have a record of what they were doing, what fuck was going on and what they were, thinking and when they decided to send a bill and all that, right? But yeah, Meg, what did you think about that whole thing with the reporter statement? Since it looks like you just got here and we were just talking about that. Meg's saying she won't print, right? And that's what I'm thinking. And that's why I was like literally just saying like, we need to be prepared for that to be the case. I mean, it was crazy. Like as Mr. Alessi was talking, I was like, dude, like, look at how mad she got last week. Oh man. Shout out to Mike P. Wow. So it's really interesting. There's like a lot of this I kind of would like to watch again. I'm not saying we're going to do it on stream, but like there's a lot of really interesting details here in this one. And as always in law, words matter, right? And semantics and all that. But this hearing today, I would say even more so than usual. And there's a lot of really clever, one thing I will say is this about Brennan. One thing he did differently on his first round at arguing this hearing was when he was quoting that reporter. If you guys heard me say it live, I said, oh my God, he's leaving words out because the way he represented that makes no sense. There was like a verb missing. He was leaving words out, right? And he did that instead of adding in words that could be provably false. So while it was still misleading and weaselly, he did that on purpose, right? Because again, it's like you have to be careful. It's like if you just leave certain words out, then it's like there's plausible deniability versus like using certain words that can be provably false, right? And again, it was tricky because I looked for it and there's apparently no video of that comment from last week. But for Alan Jackson actually saying, here's what she said, and then admitting, here's what I said, then there you go, right? Uh-huh. When Alessi said they had been paid. Yeah, I don't think I was very shocked at that point because I can't even remember now. This was a crazy hearing. Like, I assumed it was after the trial. I mean, I guess that to me, I was like, it had to be after the trial, right? And also the money was so nominal that it was clearly not going to be what you would normally pay, right? It was clearly going to be just for like their time and expenses, like travel time and expenses, right? Which I know a lot of people were thinking was the case, but we didn't know that for sure until today. So I held off because I was the information we had from last week. I was like, it's entirely possible that this was just an invoice from ARCCA that was accidentally sent to the defense because it never even said it was paid from what we heard last week, right? I was like thinking it's entirely possible this was just an accident and it was meant to go to the DOJ, right? We don't know. That last week we didn't, right? Where did you see it, Meg? You saw a video of it? I couldn't find it. Do you know how you searched for it or do you know what channel? Like I did a search for it on YouTube and couldn't find it. And then I did a search on Google and all I could find was people talking about it. I can try again. I'm wondering how you found it though. or if you knew the knowing which reporter it was a local news place, like that could maybe help. Or if it was like at the end of one of the, oh, you're saying last week? Okay. So it was, so in other words, it was happening. It would be on a court feed from last week is what it sounds like. Let me look. Because I want to see that. I don't want to take, and it's funny because everybody today was like trying to figure out what it said. And it's like, and I'm like, oh my God, they just can't pull it up and whatever. And that's so insane to me. Like, this is important, people. Like, why aren't we just pulling it up? Let me. Here's the court TV one. I don't know. Let me just see if this will have it. Otherwise, we will look for another place. So, hang on.
Your Honor, will accommodate the 20 today or no?
Yeah, okay. Not on court TV. I'll leave this open so you guys can help me look for it. It was a lady from the news after court. Okay. Of course, this is so funny, right? You can see my search up here, and what's showing me is just, it's not, you put the year. I mean, it's so stupid, right? It's like showing me the one from today and the one from months ago and whatever. So 21 hours ago. So NBC Boston, let's see if they have it. "12 hours ago." It's just so annoying. There's a clip. See, I don't think they streamed it last week. It doesn't look like it. Okay, here's CBS Boston. Let's try this one. Is this from
Let's listen in.
Alessi on behalf of Mislead.
No, this is from, nope. See, dude, YouTube. It's just so frustrating. I hate how it does this with hearings. It doesn't actually bother to pay attention to the date. It's just so frustrating. All these are from, so here's a local channel though. So let me just do it this way. This is what we're going to have to do. We're going to go to the channel. And we're going to look and see if this is the other, and I've streamed from this channel before for doing live stuff with Karen Reed. So let's just see if there's 2 weeks ago. This might be the one. Okay. It would, wait, no, wait. Streams. This is the feed that ends abruptly, I think, as in this isn't the full one. I remember, hold on. Okay, that one ends abruptly. And you're also looking, thanks, Meg. Let me know if you find it. So it's okay. That's ABC Boston. Or CBS Boston, I think it was. Let's see. Let me try this way. No, yeah, no, that, so here's CBS. Oh my God.
How can we explain
Don't do that.
WB?
No, yelling at the thing. Let's try it this way. Let's see if CBS. So there's, how is that one only an hour? Oh my God. Maybe that was the full one. I just know there's a feed that got cut off early. Hang on. Okay. Just shouldn't be as hard. That's what she said. Shouldn't be this hard. Oh my God. Let's just see this one again, guys. So Meg can't find it either. Okay, we're gonna keep trying. We're not gonna go up that easy. So maybe this was, I mean, I don't remember how long it was. You know, we watched it. Oh my God. Oh my God. I don't need my banner. I don't remember how long it was. We watched it, but I just don't remember. So this maybe this is the whole thing. I don't know. Let's just see.
Thank you.
By the defendant reference by
Oh, great. Thank you.
Is there any way she was suspended for today?
We can do the afternoon of the 25th if the morning doesn't work.
Okay, maybe there's hope.
I'm not.
No, probably not. Because yeah, there's
No,
a
I'm just
minute. Nope, that's not. There's no way. It's so fuck.
On behalf of Mr. Alessi, is there any chance the court would entertain the motion that he's doing today or no?
No.
Okay.
Why? Why are you doing this to me? You as in, I don't know, YouTube. Interesting. So Court TV stayed on longer, but it didn't stay on long enough for an interview. Let's try this. Well, now I'm wondering, maybe one of these little clips will have the reporter being like, I talked to so-and-so at the end. Let me just see. Or if it's just literally going to show the end of the thing.
He's doing today or no?
No.
Okay.
Not there. Let's try this one. Like
Okay,
maybe.
joining me now is WBZ's legal analyst, Catherine Law.
Okay.
Catherine, what just happened?
Well, Christina, I think something happened that most of us did not expect. And it's difficult because we don't have all of the information.
I don't think she's there, so that's not the one. Okay, let's just see. Meg, can you still not find it? Wow, maybe it was scrubbed. I don't know, man. Possible. It's possible. It's possible. Totally possible. Wow.
All right. So next,
I don't care about their opinions, but I care that it's unfair, imbalanced, and hidden. And the Commonwealth, like the defense, is entitled.
I don't know, man. And I did a search, like I said, that's why I did a search for it. I'll do another search for it. I did a search like just on Google. And I'll show you guys what I found. 18th. So I searched for, you can see it, Karen Reed hearing, February 18th, 2025, Alan Jackson statement. It's not even giving me what it gave me last time. Maybe I got rid of state. Let's try it without statement. It's just stupid. So we need to find things from last week. Jesus, how is it? Wow, I'm not even finding what I found earlier when I did this search. That's crazy. Let's see if it's on here. What I found earlier at least had like a summary of what was said, but weird. I'm not even seeing that pop up in the Google search now. Weird. It might have been in here. Let's just see. Oh my God. I see this. I disabled my ad blocker, and then that's what you get. Okay, here's something. Well, yeah, this is outside the courthouse. Jackson told a reporter the defense did not pay either expert to testify at the first trial last summer. So this is akin to what I found earlier, where it was just, it didn't have like a direct quote. Like it didn't have a direct quote from either person. It was literally just like put like this, kind of like how Jackson put it, right? Right. Unless you were dreaming. That's funny. What are you talking about? Oh, a UFO. Okay. Rolo. That's funny. So again, the thing with this is like, here's the thing. They were paid by the defense. However, where the kind of semantics come in a little bit, right, is like if when they were testifying, you didn't have any agreement in place, you didn't expect to pay them, you didn't actually know if they were going to testify at all when trial started, you had no idea, right? Because it was like it was unclear, and the DOJ was like the pause email, right? And then you get an email after or a bill after the fact. I can understand how that sucks, because it's like you didn't pay them to testify, right? Like, in other words, that's how that would be. It's like they came and testified and they were expecting to get paid, but nobody knew who to pay them. This is my interpretation of it. But you can see how then it sucks, because now you have to say you paid them. And so, in other words, it's one of those things that could sound bad, even if it isn't bad, because of the unique circumstances, right? That being said, I do think that that probably wasn't the best thing for Jackson to say. Now, having said that, he said the same thing today, right? When Judge Bev asked him, and she was like, if he said, if you asked me the same thing today, I'd say the same thing. We did not pay them to testify. Now, again, there's more semantics in there, right? As in paying them to testify could mean a couple things. One, paying them ahead of time, right? But also paying them for their testimony. So that, again, the sort of splitting up of the words here of like, well, paying them for their time and their travel expenses, or their time to travel and their travel expenses, is not paying them for their testimony. Oh, it sucks that they had to pay it all, because now this is happening. That's what I will say, right? That's how I feel about it. Like, it just sucks. Like, it just sucks because, like, let's just say, like, even like what Mr. Alessi said, let's say that, the DOJ sends them this bill, or the ARCCA sends them a bill, and that's when they learn, and he calls the DOJ, and the DOJ is like, yeah, we're not paying for it. And it's like, oh my God. Because now you would know when that happens, you would know, oh, fuck. Like, there, you know what I mean? Like, even if there was no arrangement, nobody expected, like, now you have to pay them, and now that's a problem. And like, in a way, it's almost like the DOJ kind of screwed you over. Like, the DOJ would have been better off making that decision and then getting paid ahead of time. You know what I mean? This is almost the worst case scenario for the defense in a way, because now it looks worse, versus just them being paid ahead of time, right? Like normal, because that's normal. That's the normal thing. That's the normal thing. But you could tell that when they were all there at trial and at voir dire, you can tell that all of them, and by all of them, I'm saying, and we reviewed it again last week. I'm saying the defense attorneys and the expert and the ARCCA daddies, it was clear that no one thought there was an arrangement. Like, that was clear. And Jackson asked the question, because we pointed it out last week. Jackson asked the question differently to Dr. Wolfe than he did Dr. Rentschler. With Dr. Wolfe, he said, you don't work for us, or something like that, right? You don't work for us. We didn't hire you. And then with Dr. Rentschler, it was like, you're not getting paid. I could have those backwards, but basically he asked the question differently, which is important to me. And I pointed it out because I said he's asking the question differently, which means he's not carefully choosing his words there because he's not worried about it. Like, for example, if you're mincing or parsing words between hired, paid, work for, then you would pick one version of what you think is going to best represent the situation, right? And you would stick with it for both. And he didn't do that. He used 2 out of the 3 on one of the ARCCA dudes, and then he used the other of the 3 with the other one. So he used all 3 different expressions: work for, hire, and paid. And so it's clear that it wasn't strategic, right? So that's important. And I don't think anyone's noticed that at all. Oh, okay. Okay, how did you find it? Or can you put it in the Discord, Meg? But isn't that wild? Like, I don't know why. I don't know that anyone else has noticed that, but I think it's really an important distinction on how he asks those questions differently to those 2 experts, because it shows that no matter how you slice it, right? Hired, paid, or work for, he wasn't there. He knew, and they knew, and everybody knew the answers would be no, of course not, right? So that's the thing. That's something that could have maybe been brought out today. Maybe Mr. Alessi didn't think it was necessary, but with Judge Bev, you just never know, right? But we still have a couple minutes to go on this just to see what happens with the scheduling. So I'm gonna go ahead and play this while I'm waiting for Meg to let me know where she found that.
We're back here next week. I believe we're back here Tuesday, Wednesday, and perhaps Friday. Is that accurate?
Your Honor, may I speak to Wednesday, please, the 5th? As this court may know, Mr. Jackson, myself, and Attorney Weinberg are scheduled to appear before the federal court at 9:30 in the morning.
Okay.
Could we possibly go there and then
Yes.
come here immediately afterwards?
Sure.
Thank you, Your Honor.
Sure. All right, but we'll see you here, Jim. We have these all scheduled at 9.
We do.
Okay.
On what day?
Immediately afterwards.
Sure.
Thank you, Your Honor.
Sure. All right, but we'll see you here, Jim. We have these all scheduled at 9.
We do.
Okay.
Wait, I'm not.
Mr. Jackson, myself, and Attorney Weinberg are scheduled to appear before the federal court at 9:30 in the morning.
Okay.
Could we possibly go there and then
Yes.
come here immediately afterwards?
Sure.
Thank you, Your Honor.
Sure. All right, but we'll see you here, Jim. We have
That's
these all
interesting.
scheduled
The
at 9.
federal.
We do.
Okay.
So Tuesday, Wednesday, and Friday, she said. Let me just double check. Jesus Christ, it's a lot of work.
Sorry.
So is that accurate?
Your Honor, may I speak to?
Yeah, Tuesday, Wednesday, and perhaps Friday. Okay, Tuesday, Wednesday, and perhaps. Jesus Christ. So that's when they will be back.
Wednesday, please, the 5th. As this court may know, Mr. Jackson, myself, and Attorney Weinberg are scheduled to appear before the federal court at 9:30 in the morning.
Okay.
Could we possibly go there and then
Yes.
come here immediately afterwards?
Sure.
Thank you, Your Honor.
Sure. All right, but we'll see you here, Jim. We have these all scheduled at 9.
We do.
Okay. All right, so we'll see everybody here Tuesday at 9. We've blocked off the day for Tuesday, Wednesday, and of course, I'll let you go to federal court first, and also Friday. All right, so see you next week.
I'm like, I don't know who Christina Rex is. Do I need to go to that channel or what? You said Christina Rex was who? I don't know who that is. Is that a reporter? Let me know if you can send the link in the Discord, maybe. Interesting. Oh, that's funny, Rollo. So, God. Alan Jackson, I wonder if he's nervous. I mean, I wouldn't blame him. I mean, because there's. I mean, the worst case scenario, like I said before, is like, I don't think excluding the ARCCA dudes. Well, okay. Or let me back up. Worst case scenario, I don't think that this is what's going to happen. Worst case scenario could be like excluding the ARCCA dudes and kicking Alan off the case. I guess ostensibly she could also say you also can't add in Mark Better, although I think that's actually unlikely. Worst case scenario could be like kicking him off the case and like Alan Jackson and then no ARCCA dudes. You can just post it and scroll through. Is there not a Karen Reed thread? I would be, if I not made, I feel like that there's got to be one, right? But maybe there's not. You can just post it and scroll through. And then second worst case. Well, I don't know. If you're Karen Reed, would your second worst case scenario be Alan Jackson getting kicked off the case or no ARCCA dudes testifying? Because that's a tough call, right? What do you guys think? What would be your second worst case scenario if you had to choose between Alan Jackson getting kicked off the case and no ARCCA dudes? Thank you, Meg. Oh, it's on Twitter. No wonder. See, I don't use Twitter. I don't see a video. Is there supposed to be a video? Okay, I asked Alan Jackson outside of court if he paid ARCCA experts to testify at trial number 1. No, of course not, he said. Okay, so this is okay, I appreciate that. So at least we're hearing from the reporter herself. I'm not seeing a video though. The video is gone. Interesting. Gosh, that sucks, man. That sucks because that's like the only way to verify, you know. But I see it. Thank you. You know, I just read it. You would say no ARCCA. I would agree. I would agree with that, Meg. I'm curious what other people think. If you had to choose, if you're Karen Reed and you're the second worst case scenario, again, first worst case scenario would be both, right? No Alan Reed, no ARCCA. Or, oh my God, no Alan Jackson, no ARCCA. If it was second worst case scenario, yeah, I would agree with Meg that between the two, I would keep the ARCCA dudes. Yeah, like no ARCCA dudes would be the second worst case. So, so maybe the second worst case scenario is she kicks Alan Jackson off the case. Or no, second worst case scenario would be the ARCCA dudes alone, right? And then third worst case scenario would be Alan Jackson alone. Wait, am I getting my order backwards? Hold on. Right, yeah. The worst, yeah. In other words, the worst thing that could happen is Alan Jackson plus ARCCA both gone or ARCCA gone, right? So yeah, so Alan Jackson and ARCCA would be worst case scenario. Second worst case scenario would be ARCCA gone. Third worst case scenario would be Jackson gone. Fourth worst case scenario would be like, honestly, beyond that, you're looking at things that would happen after trial, like maybe some fines or, you know, sanctions like that, right? But that wouldn't be that would be optimal if they're going to be sanctioned at all. He couldn't do that. He couldn't do that because he's pro hoc vice. So there's no way he could even do that. There's no way he could do that. That would be a huge problem. This already could be a problem, right? If it's found by somebody that he did this, something like this. And I just don't think he would. If it was found that he did this, like, again, like the initial allegations or the allegations by the Commonwealth that it was like knowingly, intentionally, whatever, then you got problems with the bar. That's worse. That's the worst of the worst. You don't want that. The problems with the bar is bad, right? And so working behind the scenes, oh my God, you're losing your license. There's no fucking way. There's no way. And not only that, Mr. Unetti would get in trouble. It can't happen. Can't happen. Absolutely. I don't see any way in which that could happen. In other words, like legally and like ethically. When I say ethically, again, I'm referencing the ABA. You know, when you're an attorney or even a paralegal, like those model rules of ethics are your oxygen. It's like more significant than like don't murder. And I'm not even kidding. It is. I've talked about it before. And when Denise was here and I was talking about it one time, she completely agreed. She said that when they do their CLEs every year, the vast majority of it is, again, going over the ABA rules. And you know what? They don't change that much year to year. She would have the option to stay. Yeah, she would have the option unless Judge Beth finds that she did something wrong too. I mean, you know, it doesn't seem like that's really the case here. but you know, she would have the option to. She's it's not like, you know, in other words, if there's a sanction kicking him off the case, it's just would pertain to him. She's there on her own pro hoc vice as well, right? And like as I've said before, like when I got my paralegal certificate, it really hammered that point home. Like I already knew how important they were just from covering trials and all that, right? But like when I got my paralegal, it was the same thing. Because and we didn't have to just we not only went over the ABA rules, but we also had to learn the ABA rules for the state. But then there's additional paralegal ones in addition. And then there's like a one for like the country and then one for the state. And so and it was like so much of the beginning of the coursework. And I was like, oh my God, like it's crazy, you know? And so that's what I can tell you. Like if you're an attorney, you are terrified of being found in violation of any of those. And so that's why every time there's allegations of somebody doing that with an attorney, that's why every time I look at how severe this allegations are, the more severe the allegations are, the more I'm like, I highly doubt they did that, right? I said the same thing earlier tonight about Brennan, because I'm like, if it's something that seems like it's not material, that's a little bit different, right? Again, I still probably am going to err on the side of I doubt they did it. But if it's not material, they're less likely to get in really huge trouble. But if it's material, like what we've seen talked about today, it's like these attorneys don't want to lose their ability to practice law. You know what I mean? And they would know that that's what would happen. Like, and that's why every time I consider these things, I'm like, there's just no way they did this on purpose, because the consequences are just far too severe. You know, your career's done, could be done. You know, you might be suspended first or whatever, but like, it's just such a big deal, And that's the thing. So yeah, same with nursing. Yeah. So I would not want to be Alan Jackson right now. And again, I'm not saying that because I think he did something wrong. I'm saying it because Judge Bev is presiding. She's obviously incredibly biased. Now, again, she's going to make findings as it pertains to what's going to happen to him as in regards to representing Karen, right? But in terms of sanctions or issues with the, you know, everything starts out as a sanction, right? But with the bar, that's not her call. Like I said that earlier too. Like it's not her. That's not up to her. That's going to be for the bar to decide if there's an issue. But the same is true. I was saying the same thing about Brennan, right? If he's reported to the bar, he could be found with the same types of issues. And potentially that's why one of Mr. Alessi's suggestions was like, Judge Bev, I'm not even asking for you to punish the Commonwealth. I'm saying we've got an April 1st trial date. Let's both just be adults and move on. Let us prepare for trial and then like sort this out afterwards, right? And I think that is maybe the right call, because clearly some more things need to happen. Like before, you know, I'm just reminding myself too, before I get too excited, like, or not even excited, but like, when is there going to be a ruling? There's some things that are going to have to happen. Like they're going to have to find what was said in that. Maybe they can have some sort of way to track down the video, right? Whoever initially had it probably still has it, but it's just not on the internet, maybe, right? But also they need to talk to the DOJ. There's some more follow-up that needs to be done to fully vet this whole thing out. And again, when you think of it that way, it's like, well, they've got so much on their plate. Like, I think it was a good suggestion by Mr. Alessi. Let's table this. Let's deal with it after trial, because this is a whole other thing. And then, you know, how are they? I mean, even for Judge Bev and her assistants, it's like they're going to have to, because like she needs to get information from the DOJ, right? It's not even just more work for the attorneys on both sides, but it's more work for everybody. So now, having said that, I will make a caveat here that if what Judge Bev thinks is the appropriate remedy has something to do with removing either the expert witnesses or counsel or both from Karen Reed, then that's different. And here's why. Because she will have to push that trial date out. Let me just say that. If she removes Alan Jackson or the ARCCA dudes or both or anything like that, Judge Bev knows there's no April trial date. And if she makes that decision, she's going to have to weigh that out. How badly do I want to keep this trial on schedule? Right there, I will say, if nothing else bodes well for Karen, because we know how Judge Bev is so biased. Here's what I'll say. Here's the thing. The thing that does bode well for Karen Reed is that Judge Bev wants this to go to trial on April 1st. Let's keep that in mind. There's no way she can do that. If she makes any decisions that are going to have anything to do with her trial, it's not happening. No way. No way. We're looking at months down the road. So, and yeah, same. So if nothing else, it could be that her desire to just get in and out really quickly, Judge Bev just never wants to be there. That could be the saving grace for someone like her who maybe, if not for that, would try to fuck it over, right? Like maybe if not for that trial date, right? Maybe she would say, like, let's just say this had happened I don't know, 8 months ago, or I don't know. I guess the other trial was still happening at that point. Let's just say it happened 4 months ago. Maybe she would have said, fine, yeah, we're getting rid of Jackson, we're getting rid of ARCCA, whatever. But I'll tell you what, like, if nothing else would make a difference, that trial date might make a difference here for her. Like, what is she more of? Is she more biased, or is she more wanting to just get shit done quickly? I mean, and it could be that if she goes that route and to keep the trial on schedule, it could be that there's still going to be some other severe implications after the trial, as implications for Alan Jackson, right? Or Hank Brennan, both, right? Either way, but that Karen Reed at least would get a fair trial, and it wouldn't affect her. And I mean, it's not that the thing is it's not fair to affect her, and that's why Mr. Alessi brought up the Sixth Amendment so much, because it's not fair for her to be punished. Like, she shouldn't be punished. So, and again, that's another thing that would bode well for, because even if she pushes the date out, like let's say that Judge Bev really wants to remove Alan Jackson and the ARCCA dudes, even if she pushes the date out, that's still punishing Karen Reed, right? So when you think about that, again, that bodes well for those things not happening, because you really don't want to punish the defendant. So, man, it's wild. And so earlier tonight too, for anyone who missed it, we did cover the latest for out of Idaho with the motions in limine from the state. I'll be waiting with bated breath for more to come out. That has been listed on the case summary, but not available yet. Rolla says BRB. That's okay. I think we may not be here when you get back, because I think we're probably wrapping up here. But Donna Adelson also has a bond hearing rather, tomorrow. So yeah, interesting stuff though. I feel bad for Alan Jackson. He's got to feel so nervous. Brennan should feel nervous, but he probably doesn't. Karen Reed didn't look too worried though. She was smiling and laughing a couple times when it showed her towards the end too. So I don't know. We'll see, right? We will see. So, but that's it for this one, guys. So love y'all. And Squirrel Crew's the best. For anyone who missed it too, I did mention, shout out to DSN. He put a link in the Discord under the Zachary Hughes thread that has something he found on Reddit, has like all the court documents categorized by person. And so that is awesome for anyone that does want to check those out, because we need to do a follow-up with that as well. Hoping we hear from a juror. But anywho, that'll be it for this one, guys. And I will see you guys next time.